to stay one of this matter. But while writing the order, the PRC case number is exchanged with the CR number, and
We'll do it right now. Yeah.
84 supplement.
Huh? 84, item number 84 supplement.
84 supplement.
We'll do it right now. We'll take it up as the first item. Yes.
I have to mention item number 61, my lord.
61.
My lord. 61 and my lord 73. Both the analogous matter, may I please that, my lord? Both may be analogously listed in future, my lord. And second thing, my lord, for determination of the
Upgradation to Kikole. Put no. Which item number?
84.
Supplementary list.
Supplementary list is still 77. Do we have an 84 in today's list? You want item number 61?
61 and 73, my lord. Both may analogously be listed, my lord. And second thing, my lord, item may be sent to the Lavajma court for determination of the service of reports, my lord. And interim order may pass earlier, may continue.
Yes, what do you say, PP?
No,
item number 61 and 70?
61 and 73.
73, huh? But Mr. So-and-so, Learned Counsel appearing for the petitioner. The matter be listed before the Law Zima court for verification of the service report on the respondent number
2 and 3.
Since it has been submitted that both the matters are analogous, list the matters. The matters we take together and listed hereafter.
And my interim order may continue, madam.
Interim orders shall continue till the next date of listing.
Master.
In item number 36, I have filed one letter to it. I will be allowed to bring the letter.
Please, Lordship. My lord, I beg to mention for listing and bail hearing matter, my lord, it is fixed on 9th of January, my lord. But it is not listed, my lord. But tomorrow, my lord.
9th of
9th
January. Tomorrow?
Tomorrow, my lord, CD is also available, my lord. The matter was left over, my lord. Highly blessed.
Tomorrow.
My lord, another, my lord, mention, my lord, in item number 25.
25.
Hi, my lord.
Yes.
Some witnesses were examined in the trial court, my lord. So that may be called for, my lord. And matter may be fixed after 2 weeks, my lord.
At the request, heard Mr. So-and-so Learned Counsel appearing for the petitioner, he submits that in the meantime, some more witnesses have been examined by the trial court and their statements may be called for. Stop. Learned PP does not object to the said prayer. List these matters again on.
My lord, on 6th February.
Can be addressed on 12. Are we free on 12? Just a minute. How many matters in 12? On 12th. Itu maatu keneke bodlai? Palu. On 12th, we can have it. 9th or 12th? Which date?
9th, my lord.
9th. On the 9th of February, we'll stop. In the meantime, the updated trial code, scan copy of the updated trial code records be called for.
Wait, this is your lordship. In item number 10, your lordship, the lordship may allow us to withdraw with the liberty to file afresh. Item number 10, your lordship.
You are Miss?
S. Sarkar.
Appearing on behalf of the Learned Counsel for the petitioner has submitted that they are under instructions not to press this anticipatory bail petition in its present form and to seek liberty to file afresh. Full stop. Prayer not being objected to by the Learned PP.
And for the respondent DSP.
Oh, the prayer not being objected to by the Learned Standing Counsel DRI.
GST, lordship.
Huh?
GST. It's wrongly written as DRI.
By the Standing Counsel GST, comma. The same is allowed. The anticipatory bail petition is closed on withdrawal with the liberty to apply afresh. Yes.
For listing, lordship, regular bail get a lordship for motion.
Not tomorrow, we'll have it there on. Huh? 27th of June. Huh? On 27th.
May please, Your Lordship.
Yes.
Lordship, regarding item number 50, perhaps
Ah.
case diary is not available, madam. There's an interim order.
Mr. So-and-so appears for the petitioner. Learned PP has submitted that the case diary is awaited.
55 0. My lord, may take it, let the matter reach, my lord. Read.
Lordship, on request of NDPS, DK Bhattacharya, I'm appearing on his behalf, find that on duty medical emergency of this, mother, you could not attend this. Kindly accept the matter. Item number 75 under supplementary.
A request has been made on behalf of the learned amicus curiae that the matter be adjourned today, as he is unable to appear. Stop. List this matter again on
Besides, for the of February,
16th. Hi. You don't want 17? Then we'll have it on 16.
16th of February.
My lord, item number 42, she's for the CBI and I'm for the petitioner. On the last occasion, in fact, this is a charge sheeted matter. So ideally, the TCR ought to have been called for, but inadvertently, I do not know, in the record, it appears the CD is being called. So the TCR is not there. So my lord, without TCR, perhaps.
Heard Mr. M. Biswas, learned counsel, appearing for the petitioner, also heard the learned standing counsel CBI. It has been submitted that the matter that a charge sheet has been submitted. Full stop. In such view of the matter, call for the scanned copy of the TCR. List the matter again on.
Next week, my lord, we have some urgency because for more than 100 days, the gentleman is behind the bar. And it is from Guwahati only, Chanmari.
4th or 5th? No, 5th is too much. 4th?
Let it be on 3rd, my lord.
22 matters already fixed.
Then 4th, my lord, I'll the convenience.
4th.
And it
May it please your lordship, I beg to mention item number 44, prayer for Passover.
Prayer for?
Passover. Yes, 44.
Heard Mr. So-and-so,
Lordship, interim may be continued.
Heard Mr. So-and-so, counsel appearing for the petitioner. The learned APP has submitted that the CD is not available. List again on the 9th.
Earlier, the case was got to was 85 exactly. Subsequently, I have received a signal, Malak, this transfer to Panbazar PF Malak. So now, Malak, the city of the Panbazar PF may be called for.
Okay. List again on the 9th of February 2026. Full stop. Learned APP has submitted that although initially the case was registered as Gorchuk PS case number
55 of 2025.
subsequently, it has been transferred to the Panbazar police station and is now registered as now has been transferred to the Panbazar police station. Full stop. Accordingly, call for the CD from the Panbazar PS with relation to this case. Have I given a date? I gave 9th, no? Okay.
9th of February.
Obliged.
Additional affidavit. Obviously.
May I please, your lordship? Your lordship, I beg to mention item number 55, your lordship, for adjournment as the council is out of station, your lordship. Your lordship, the matter may be fixed on 27th Feb.
We'll see. When can we fix it? We'll see. Mr. So-and-so, the counsel for the petitioner has submitted that the matter may be adjourned today. Stop. Learned PP does not object to the same, accordingly lists this matter again on 27th, not possible, 30 not possible. The first date we can give is the 4th or the 2nd. 2nd of February or 4th of February, choose.
28. 28, your lordship.
I have given you a choice of two. 2 or 4.
February.
2nd of February.
Highly obliged, your lordship.
Hmm.
Calling the adjournment.
Okay.
May I please, your lordship, I beg to mention supply list of item 76.
Hmm.
Due to some personal difficulties of my senior, matter may be adjourned for the day.
At the request of Mr. So-and-so appearing for the learned counsel for the petitioner, list this matter again on
Lordship, as per your convenience.
5th of February.
Highly obliged.
Yes.
With respect to 48 losses.
Hmm.
Accommodation losses. That's what CD is also not available. This is not the key.
Not received. Heard Mr. So-and-so learned counsel appearing for the petitioner, learned APP has submitted that the CD in the matter is awaited. Accordingly, list on
40, 30,000.
Then also better be, I have it here, I will, because of the, I have to.
we'll have it on the 4th. On the 4th of February. Mr. Learned APP submits that the charge sheet has been submitted.
And I also, let me, inquire with my client, as per yesterday evening. he informed me-
We are assuring you this court is not coming between you and your client. Find out whatever you want to.
My
Yes,
lordship,
yes.
item number 47.
47. Yes,
Amicus Curie A. Fukan not present for health issue.
okay.
Kindly adjournment for.
Have you informed the petitioner?
No, my lord.
Huh?
No.
Let the matter reach, you inform him.
No.
He may want to place it, yes.
Thank you.
Ah. Hmm. Mr. D. Gogol and a counsel appearing for the petitioner has submitted that is present. Stop. Learned Special PP has submitted that the CD is awaited. This matter again on. You are on interim.
Yeah.
We'll have it a little later then, huh?
20.
Not this month. Football. We'll have it on the 9th of February, 11th of February. Interim order passed earlier shall continue.
May I please,
Yes.
your lordship, I beg to mention for listing a bail application for tomorrow for motion.
Tomorrow we are too heavy.
So he is jail since for last 70 days.
Oh, he's in 70 days. Kali kimanot asa no? Eh? 21, we see. Today holiday. 22 is not 22, 23. For motion.
Yes. Oblige.
Oh, motion CD.
BN number 118W26, the matter may be taken up with item number 43 of daily.
Where is that? Is it listed today?
Yes, yes.
Both the matters are listed today.
Same apparent. The
Both-
matter may be not covered. The first list.
Both the matters are listed today.
Not listed.
Then
This matter listed yesterday, 21/53. 2026, yesterday, you know, yesterday morning mentioned that arising out of same affair, that matter may be listed, taken up with item number 43 of today, daily list. That
I'm not understanding. Are both the matters before this court today? Yesterday. Did I make an order for it to be listed today?
Yes, there is the order.
Yesterday's item number? Mr. Parasar, kindly tell him the information that we need to have the matter called for him. He has to check whether yesterday we had passed such an order. If it is there, then I'll file to preside over. What does it say? For today. Material এখন বিয়ে খুঁজাই দিয়ক আজিকান যদি লিষ্টিঙত দি থোৱা আছে খুঁজাই দিয়ক in supplementary list. What is your item number, case number that you want today? হ্যাঁ বেঞ্চত চনি হৈছে নাই সেইটো ঠিক নাই 5খন নে 6খন ফাইল আছে নেকি কৰাই দিছে তো তেতিয়াহ'লে খবৰটো লওক okay we'll have it at 2. We'll take up both at 2.
May I please, your lordship. Lordship, I beg to mention item number
You kindly give that in writing. Yes, sir. Kindly give the petition number in writing at least. Petition number and item number. Yes.
Item number 71, lordship.
Hmm.
Conducting counsel is out of station, lordship. Kindly pass over that day.
At the request of the learned counsel for the petitioner who is stated to be out of station, list this matter. List this matter again on. Are you on interim?
No, lordship, charge-sheeted matter.
Charge-sheeted matter.
Every. Lordship, first week of February, anything.
4th of February.
Objection.
May I please, your lordship. My lord, petitioner struck me item 11. He want to not press my lord.
Why?
My lord, already case is charge-sheeted, but his name is drove in charge sheet, my lord.
Mr. Swensel and counsel appearing for the petitioner has submitted that he is under instructions not to press the present petition since the charge sheet has already been submitted in the case and he has not been put up for trial.
Yes, sir.
Accordingly, this anticipatory bail petition is closed.
Yes, ma'am.
I did to mention item number 49 is hearing matter.
Hmm.
CD was to all for CD order.
49 years, but still not.
Mr. Swensel, learned counsel is present for the petitioner. Learned APP has submitted that the CD as called for has not been received. Accordingly, list the matter again on the 7th of when?
Okay, then you confirm, no, last time.
How many occasions CD was called?
Okay. On 9, ballot. I'll just remember.
On the 9th of February 2026. Are you on interim?
No, I'm not.
Oh, then you have to hurry up if it has been on several occasions. We'll bring it up to 5th.
Okay.
On 5th of February. Huh?
May I please, your lordship?
Yes.
Mention for listing the matter for motion on tomorrow.
Tomorrow.
It's an AB case.
Huh?
It's an AB.
Kali kana 26 month hole sir. Motion. Okay. Yes.
May please, your lordship. Lordship, with the consent from the other side, I beg to mention item number 24. Lordship, they have filed their objection. We need 4 weeks time to file a reply.
24. Mr. Swensel and counsel appearing for the petitioner has submitted that he has received a copy of the objections filed by the respondents and would require some time to go through the same. The prayer is not objected to by the learned counsel appearing for the respondents. Accordingly, list this matter again on
After 4 weeks, first week of March.
first week of March. Okay. The first week of March. 5th of March.
Much obliged. Lordship, I beg to mention a bail application for listing tomorrow, your lordship.
I think Monday would be a better choice. Huh?
Yes, Already in detention, your lordship, therefore I'm requesting.
Huh?
Already in detention for some time, your lordship.
I understand. If he's in detention, anyway, tomorrow we are not, there are very little chances that tomorrow we would say yes, release him.
But your lordship. process
Unless
will
you can
start.
show us it's a totally, all things are done.
Your lordship may consider.
We'll have it on 27th.
Tomorrow, kindly, your lordship.
Tomorrow we have fixed 28 matters. Then there will be other matters which are already on the list.
It will take, your lordship, if motion is there, your CD will be called, your lordship, it will take very less time, your lordship. Kindly, your lordship.
Okay.
Much obliged, your lordship.
So I have to mention here item number 40 of today's list. Here TCR not received as per office note.
Mr. So-and-so on a council appears for the petitioner. The office note reveals that the TCR as called for, the scan copy of the TCR as called for has not been received. Full stop. Issue reminder calling for the scan copy of the TCR list again on.
Lordship, 6th or 9th.
6th of February 2026. 6th of February. No, we'll keep it on 9th of February.
Obliged, Lordship.
Yep.
Item 1 is this mandatory period over. So today
Huh?
60 days. Mandatory period is also 60 days.
Yes, today it is over. Do you have a file lecture sheet? No, I'm not. Offense report may be called for. The statutory period is 60 days, as he says. If you have not put in the charge sheet, it's a default bill. Have your instructions at 2.
At 2.
At 2. Have your instructions at 2. We'll see.
Lordship 103 and 118 to BNS, Lordship. And they are behind the bar since last 25/4/2025, Lordship.
Huh?
Procedural, please. Trial started, but no witnesses has been examined till date, Lordship.
Huh?
No witnesses has been examined till date, Lordship.
Huh?
All total 53 witnesses, Lordship.
Someone has. So we'll call for the.
I'll call them.
Mr. So-and-so appears for the petitioner. This is a bail petition under 483 of the BNSS praying for regular bail in connection with Pulibar case number, you go by page 1, huh? For the petitioners who were arrested and forwarded on 25/4/2025. Call for the scan copy of the TCR. Please.
Case number 86
Call for the scan copy of the TCR
Yes, sir.
instructions case number.
86/2025.
List again on when 11th of February.
Of life.
That please, your lordship. Lordship, this is regular bail application, lordship. Poxco section is here, lordship. But about 8 months, 1 days in custody, lordship. And charge sheet already been submitted, lordship. And CC is conducted on the 25/2025 in the March of May, lordship. And on 20 May 2025, CC lordship frame, lordship, and subsequently, lordship, no witness has been turned upon today, lordship. So there is short date, lordship, and otherwise, lordship, and there is the settlement is there. Otherwise, the victim is above 18 years, but
Ensure service of the notice
Sir,
as per prevalent notification on an early date.
lordship, can be 3/4, lordship,
Huh?
3 or 4 February.
Both we can try. Will you be able to serve by 4th?
Lordship.
9th. You have the Poxco order, na? Give some samples. Application, this is an application under section 483 of the BNSS, praying for grant of regular bail to the petitioner who is in custody since 25/2025 in connection with special Poxco case number 41 of 2025 pending in the court of the special judge within bracket Poxco Vishwanath, Vishwanath Chariali. Huh? Issue notice to the respondent number 2 as per the prevalent notification. Call for the scanned copy of the PCR from the concerned court. Full stop. List again on the 9th of February 2026. Okay. This will be a part of the standard order which we pass in the Poxco cases. Huh?
Obliged, Lordship, obliged.
Huh. 11 to mention কৰিছে who appear the matter 12 to আহিব না কোনবা 11 এ mention 12 to এই রাহুল same person same হেৰি এতিয়া দুইটাতে একেটা অৰ্ডাৰ কৰে এটাত নকৰে যদি দুটো নকৰে দুইটা মেনশন কৰি দিয়ক হা
May I have his lordship? Lordship, page 50, Lordship, I am on the violation of the under section 447 of BNSS, Lordship. The grounds of arrest not provided, Lordship. Kindly see the notice, Lordship. It is page 50. It is under section 50 of CRPC. Now it is 47 BNSS, Lordship. The contents of the notice. You are hereby informed that you are arrested in connection with the above reference case and the case is cognizable and non-bailable. So you are forwarded to the court. You may submit
from
petition.
2022 today you wake up to say that you don't the notice was not complete 2022
Yes,
it took you 3 years to understand
Yes, 3 years, 7 months, Lordship, 19 days today.
Ha, ha, ha.
Yes, Lord.
it took you 3 years to understand that this notice is
Lordship, yeah, he's coming lately, Lordship.
huh let the records come we'll call for the scan copy of the records otherwise you'll be this is prior to or after what is that situation you don't know huh prior to a particular judgment and after a particular judgment this 21 thing comes in which are the cases Vihan Kumar and prior to that
Pravi Prakasta.
what is the date of Pravi Purkasta 23 23
15 May
Because-
2024.
2024
Yes.
this case is prior to that
Lordship.
will it be applicable all these arguments
Applicable to the retrospective effect is there, Lordship.
it is there
Yes, Lord.
retrospective effect is there Mr. Parasar retrospective effect is there for Pravi Purkasta I think Justice Goswami's judgment and my judgment and one more judgment. Otherwise, everybody will be coming.
Lordship, may I read
That is why. Anyway, how
may I read only one paragraph? It's Article 22 of 22(1) Lordship Constitution and one paragraph. May I read Lordship Vihan Kumar, Lordship? Does the requirement of informing the person arrested of the grounds of arrest is not a formality but a mandatory constitutional requirement. Article 22 is included in Part 3 of the Constitution under the heading of fundamental rights. Thus, it is fundamental right of every person arrested and detained in custody to be informed of the grounds of arrest as soon as possible. If the grounds of arrest are not informed as soon as maybe after the arrest, it would amount to a violation of the fundamental rights of the arrestee guaranteed under Article 22(1). It will also amount to depriving the arrestee of his liberty. The reason is that as provided in Article 21, no person can be deprived of his liberty except in accordance with the procedure established by the law. The procedure established by law also includes what is provided in Article 22(1). Therefore, when a person is arrested without a warrant and the grounds of arrest are not informed to him,
Mr. Counsel,
Lordship.
today it is on motion.
Yes, Lordship.
We have to either call for the records,
Lordship.
scan copy of the records, or we have to let her file her objections to the same.
Yes.
Your
Yes.
reading of the entire judgment
What-
would
what-
not,
what-
it will not make us give you a bail today
Lordship.
without either calling for the records or giving her an objection,
Lordship.
an opportunity of objecting to.
Lordship.
Is it not?
Lordship.
Do we need to go through it now? It's 11:05. I've got 77 matters.
Lordship.
We'll do it on a day when the records are there and when the objections are here. Yes. Heard Mr. So-and-so, counsel paying for the petitioner. So anything prior to that, does it apply? Perhaps not. Find out the judgment. Perhaps that only that ground may not help you. Only that ground will not help you. This court has held that something which, that arrests which were made prior to the probable Poxco judgment,
Long incursion.
this notice in this format, only that challenge is not going to help you.
Yes.
There has to be something more.
Lordship.
Go through it.
Lordship.
Heard Mr. So-and-so, counsel paying for the petitioner, also heard the learned standing counsel. NCB. This is a petition praying for regular bail in connection with final complaint dated 28/1/2022 in connection with NDPS case number 34/2022 arising out of NCB crime number 14/2022, full stop. Learned counsel for the NCB has prayed for an opportunity to file the objections and to produce the case diary. The matter. List again on? PCR will call for. To file her objections, full stop, list this matter again on the 12th of February 2026. Stop call for the scan copy of the TCR.
Your Lordship,
Yeah.
483 application, Lordship.
Ah.
The prisoner was arrested on 14/1/2026, Lordship. FIR will at page 14, Lordship, you will find that.
1-4.
14. My lord, I am not named in the FIR. My lord, the allegation in the forwarding only that, Lordship, the earlier arrested accused person whispered my name. That is why I have been implicated in this case on the night of Uruka, Lordship.
Why do you apprehend arrest?
The other person arrested in this case, some persons arrested, they have whispered the name, my lord. That is the allegation against me, Lordship. And Lordship, here, the mandatory 2 sections they have not complied with, Lordship. One is no notice under 35, Lordship, BNSS, and the notice under 48 also, Lordship. Lordship will find that I have annexed this document at page number 25 in forwarding, Lordship. It is stated in their writings, Lordship, last multiple efforts have been made to contact with relatives. See, no response can be.
Where is it? Where is it? Which page are you reading?
Last page of 25 at the handwritten column, Lordship.
Efforts have been made to contact with the relatives, but no response can be.
My lord, and thereafter, WTO message sent to OC Hajo PS. My lord, he has been arrested from the house, Lordship, at the night of Uruka, Lordship. It is completely false allegation, Lordship. No notice served to the relatives, Lordship, on that night. And this is the case of Patsala. He is the resident of Hajo, Lordship. So, and notice under 35 also not issued, Lordship.
Swensel Learned Counsel appearing for the petitioner also heard the learned PP. This is an application under 483 of the BNSS for granting bail to the petitioner who was arrested on.
14/1/2000,
Is this your petition?
my lord.
Is this your petition?
My lord, I'm sorry, in the, my lord, it is written in here, Lordship, in page number 2. Page number 2. Thirteen 1/2026. And it is
Number?
page number 2 in the matter of the name of the petitioner and bottom in jail.
Your post title says 6/6.
No, my lord, this is typographical mistakes. My lord, that is, I'm sorry, my lord, that is typographical mistake. My lord, it is written in the bottom, Lordship, at page number 2, Lordship. And it is mentioned in the forwarding report, Lordship. I'm extremely sorry, man.
Who is in jail hazard since 13/1/2026 in connection with Patsala PS case number 3 of 2026. Stop. Call for the updated CD. The learned counsel for the petitioner has submitted that due to a typographical error in the cost title of the the date of arrest has been shown as 6/6/2025 and 6 permission to have the same corrected by hand by correcting a copy also given to the learned APP. Full stop. Permission is allowed. Is it contained in the cost in the CIS?
Madam, I'll file the additional affidavit, Lordship. Phrase amended.
The learned counsel for the petitioner shall submit a corrected cost title
Madam,
to the registry within 2 days.
Lordship.
Full stop. Did I say call for the updated case diary?
Madam, it's from
Please.
Patsala, Lordship. Can it be
Placed again on the 9th. Huh?
Can it be earlier date, Lordship?
9th.
My lord, already he is not involved at all, Lordship.
I understand.
Only on the basis of the statement, my lord. Only on the basis of the
2
statement.
days down the line, you will find a corrected. Within 2 days, you will file the corrected thing. Then he will ask for the CD with the corrected copy. 26 till 20.
It's correct, my lord.
Till 26th of January, everybody is busy.
My lord, PS case is correct. That is well, Lordship. Can it be on the 4th or 3rd, Lordship, if possible? Only 2-3 days earlier, Lordship.
4th. Yeah, 4th.
Obliged, Lordship.
Here, FIR Lordship will find page 9. He is in detention since Lordship 4/11/25. It is 79 days as on today, Lordship. Page 9 is the FIR.
And Mr. Swensson, counsel paying for the petitioner.
From the FIR, Lordship will find that marriage took place 12 years back, Lordship, and that dowry allegation is that after 12 years. And in fact, last
And the
line
death allegation is?
Lordship.
And the death allegation is?
Or
A death has occurred.
Lordship,
Whether under dowry or not, a death has occurred.
but in fact, Lordship will find
Under
that he
unnatural
himself took the victim to the hospital, Lordship.
Yes.
Would
Would it take away the apprehension of
that probably
feeding poison?
103 will
Huh?
not come. Probably 103 will not come.
Asu?
That
At this stage, whether you are supposed to be outside or should we go through the CD and materials available against you?
9 days as on today, Lord.
Huh?
79 days today, Lord.
Huh?
Yes, I'm praying. The detention period, Lord, if your Lordship considers.
In this kind of case, where the wife has expired due to poisoning,
Probably, Lordship, it is 108 ought to have been, Lordship. But if you're 108, then 60 days mandatory period. But
so the
yeah,
police writing down a wrong section of law would entitle you to bail. I'm
for
just
that,
asking, we are just trying to find out.
No, because
My
not
expression may not be too, yes, huh?
Not because of wrong section, Lordship.
Let-
I'm from the nature of the allegations level in the FIR, Lordship. From that, I'm
What is that nature of the allegation? Which allegation do you want to say?
after 12 years, Lordship, only one date is given that demand was made, Lordship.
Okay, we say that there is no demand for dowry, then the next line.
Lordship may consider the detention period, Lordship. That,
Today,
no, 79 days.
assaulted and
Because last line says he himself took
Accused
the,
assaulted my sister and fed her poison against her will.
and then he got
Accused
admitted
fled from the hospital.
after death, Lordship. Because
Ah.
Lordship knows that after death, there are cases, there is apprehension that cases will be lost there. So those things are there, Lord.
Application under 483 of the BNSS in connection with Sri Bhumi PS case number 447 registered under section 1031 of the BNS. The counsel for the petitioner has submitted that looking at the nature of the allegations, since 12 years had passed from the date of marriage and the length of detention at 79 days, this court may consider an interim bail while calling for the case diary. This court is not convinced to do so at this stage. Call for the case diary on Sri Bhumi.
So maybe on 30th.
On 30, on 30th,
29, Lord.
on 29, one day before,
Obliged, Lord.
one day before.
Here in this case, Lordship, Poxco matter notice may go, Lordship.
That Poxco order that had given, same thing, you just take down the details from this, huh?
Obliged, Lord.
The FI Lordship on page 9, Lordship. Have a look at the FI Lordship, further custodial detention might require or not, Lordship. Otherwise, 18 days in behind the bar, Lordship.
Page 9.
Page 9, Lordship, annexure, only typed out copy, Lord. Lordship, what happened is a garage, Lordship. He stole some money, so some slap and all has been given, Lordship. The only thing, the apprehension that mother thought that we might lose a police case, Lordship. Only because of that, to restrain us, this thing has been done, Lordship. Father, Lordship, no medical treatment, nothing, Lordship. Simply, Lordship.
The age of the victim? What is the age of the victim?
Victim, Lordship, is a minor, Lordship. Admittedly, is a minor, Lordship.
When? 14. No, no, when can you have the CD? When can you have the CD?
In a format, Lordship.
How many days you are behind bars?
18 days, Lordship. Further custodial detention might not be, only their apprehension that we might lose a FI, Lordship. That is the thing. And the forwarding report also.
Allowing him to, you are who? You are the owner of the garage?
No, garage. Lordship.
Owner of the garage, then they also have this child labor.
No, Lordship, that some comes up, when mother herself says that he works there for livelihood. Mother's Lordship is a widow and allow him to work. Many charges are there. There is no forced labor, Lordship. It is not forced, Lordship. Whatever maybe, Lordship, some we did not lose any FIR, did not inform police also, Lordship, regarding that part.
There would be an injury report.
No injury.
No. There is an injury. There are injuries. That is what I'm
No,
saying.
says that only assault, Lordship, no injury.
Lorajনৰ শৰীৰত বেয়াকৈ জখম আছে. So what is that বেয়াকৈ জখম? Let us see how far they hit a 14-year-old. When can we have the injury report?
That part was there, Lordship.
Huh?
Slapping and all was done. That
is what we would just want.
admittedly, Lordship.
That is just what we want to see, whether it went to the
The only other part is that we did not call the police, Lordship. We did not lodge any FIR, Lordship.
Could not have. Juvenile.
We thought
He'll
that
go
Lordship,
home.
there is a minor boy, Lordship. He might learn a lesson, Lordship, that he is caught, Lordship. So we did not went further.
Huh? 29. 29 we have already fixed. This will be a 31st case. 30. Let us try to have the injury report. The only thing is, if 5 people have been beating up a young boy.
Injury report, Lordship, no medical has been done, Lordship. As for he was
Of the victim?
nearby that, Lordship. No medical has been done, Lordship.
If it is no medical, you are safe on 30th.
And they will take time, Lordship, for medical. Already 18 days, Lordship. Father, Lordship, the working, paying, Lordship, everything is there, Lordship. Only to
give him a good lesson, Lordship, that has been done, Lordship. Parents also does, Lordship, that thing. The mother herself is in a forced labor, Lordship. He was not picked to forced to work, Lordship. The mother herself says that. The FIR contains, Lordship, mother herself says, Lordship, that.
Have you seen the forwarding, sir?
Says that where my son has
Have you seen the forwarding?
I have seen it, Lordship.
Page 15?
The police says, Lordship, the injury mark, Lordship, is visible. Police says, Lordship. No, police says, Lordship, that revealed, Lordship, in FIR as well as in the forward.
Just let me have a look at the, if the injuries are not, injuries are one of slaps.
Medical has not been done, Lordship, there is not serious, Lordship. Otherwise, it would say that for medical treatment, one line would be added in the FIR, Lordship. Always we see that, Lordship. Or in interim, Lordship, let the medical, because we know, as you've seen, Lordship, when medical is not done, Lordship, time is regularly taken, Lordship, for medical treatment. If Lordship allow on interim, Lordship, then let the medical report come, Lordship. If there something is there, my
Yes,
bail
what
pair,
you say?
my bail pair rejected.
Third and fourth.
Except Lordship says that mark is in Lordship injury, but other than Lordship, nothing is there because mother herself said that he works there to earn his livelihood, Lordship. And the forwarding report also says, forwarding report also says that. That what Lordship police we have many times we have seen in the forwarding report.
If there is no injury report, we'll consider it. Heard Mr. Swenson, learned counsel appearing for the petitioner, also heard the learned APP. The learned counsel for the petitioner has submitted that the FIR had been lodged only to restrain the mother of the applicant from mother of the victim from lodging and by the mother of the victim to restrain the accused herein from lodging an FIR against the victim for committing theft in the garage premises. The learned counsel for the petitioner has submitted that the victim may have been manhandled to teach him a lesson against the theft, alleged theft, and there was no intention to cause any
loss,
injury, etc. to the victim. Full stop. The learned APP has submitted that a perusal of the injury report, if any, would be necessary to find out the extent of assault caused. Full stop. List this matter again on the 30th of January 2026, by which time the learned PP shall ensure that the injury report is placed before this court along with the case diary. Full stop. It is noted that the petitioners have already spent around 17 days, 18 days behind bars. Full stop. If it does not, I have recorded as well.
Much obliged.
Yes.
My please, Lordship. Lordship, I'm behind bar for 76 days and mandatory period is 60 days, Lordship. NDPS Act 21B, 27A, along with 29, Lordship. 60 days.
No charge sheet.
Lordship.
No charge sheet.
No charge sheet.
Funding.
27A is a consumption.
Second 37 also come.
Why 27A? Why the doubt of 27A? Huh?
No finance, Lordship. Kindly come to the page 8, Lordship. FIR is there.
During the investigation, request person has called how does they professionally carrying out such supply
But there is no whisper about the money or like that, lordship. Ground of arrest at phase 11.
Hmm.
There is no whisper about funding, lordship.
No, page 11, the grounds do not reveal that you told him that he's.
But I am for 76 days, lordship, kindly considering my detention period. I mean,
No, with 27A being inserted, we will have to call for the CD. We're just trying to see. This heard Mr. So-and-so and counsel appearing for the petition also heard the learned APP. This is a bail petition under section 483.
FR does not show like
43 of the BNSS for granting regular bail to the petitioner who was arrested on 5/11/25 in connection with Hojai PS case number 328 of 2025. The petitioners have been arrested on recovery of 15.11 grams of suspected heroin along with vials, full stop. The learned counsel for the petitioner has submitted that the petitioners have already been in custody for 79 days.
76 days.
76 days, which is beyond the statutory period. No charge sheet has been submitted till now. However, the learned APP has submitted that with the introduction of, with the, since the learned APP has submitted that since the, there are allegations under section 27A of the NDPS Act also, a perusal of the case diary would assist in considering the bail petition, full stop. List the matter again on the 7th of February 2026.
7, I think, lordship, 90 days will cross.
Hmm?
Because today is 76 days.
But in case of 27,
180
It is
days.
Saturday.
in case of 27,
Uh-huh.
Yes, lordship.
with no 90 days.
90 days.
Otherwise,
90 days will not
180
come in.
days, sorry.
180 days will not come
There
in.
is
We'll
no-
have it on 7th of February. মই second কৈছিলো আপুনি 7th কৰিব দিলে দেখোন 2nd of February. 2nd of February.
Okay.
2nd of February.
2nd February. Deeply obliged.
We'll just see if there's anything regarding your financing.
Let's repeat. There is no finances.
If there's no finance,
In vacancy long, that is.
That's the allegation, lordship. Whether
the amount with the vials do not show that they were trying to sell it.
definitely, lordship.
No recovery of any money.
No money, lordship.
Selling means
Deeply obliged, lordship.
Yes. 12, 11 was mentioned. Anybody appearing for 11?
so 11
11 is with 12. 11 has been mentioned. Same person 12. Why?
Yes, madam.
Ah,
Malad 11 was Nazire PS case number 33/2025, and the present item 12 is the Nazire PS case number 36 of 2025.
so you want to do this?
Yes,
Yes.
no, 11 I have done because 11 already succeeded. I am not in the succeed.
12 we will
Yeah,
take it.
12 I am pressing, madam.
Ah,
In 12, my lord, the last occasion case there was called for.
Ah.
And here, my lord, in my house, my lord, nothing was recovered, my lord. 33 succeeded for another person. And here, my lord, the FIR is page 16. The police got the information from reliable source that, my lord, 2 numbers of drug peddler is hiding in my house.
hmm.
According to police come, and I was not present at the home. And one accused person, my lord, as per police, my lord, he was arrested and found in my house, Najim Ali. And in my house, nothing was recovered. It clearly mentioned third from bottom, my lord, third line, my lord. The independent witness have, however, no NDPS substance was found in the house of Rahul Ali.
Which page?
Page 16, my lord. 16.
Ah,
Third paragraph, my lord, last 3 line. Well, the Rahul Ali was searched in presence of the independent witnesses. However, no NDPS substance was found in the house of Rahul Ali. After that, Bolero vehicle parked in front of Rahul Ali's house was seized in presence of the independent witnesses. Later, house of Nazim Ali was searched as per the authorization provided, and from Nazim Ali's house, my lord, 10.60 gram suspected, my lord, drugs was recovered, and he is, my lord, so distance, and he is one of my relative, my lord, only on that ground, my lord.
So why did you run away from his house?
Actually, I was not there. The police mentioned Nazim came, but informed me I have come. In the meantime, I was in outside. Before reach my house, police came.
10.6 gram.
And that is from Nazim Ali's house. And my house from nothing.
Yes, what do you say?
Maybe protect, my lord. And Nazim also released on bail, my lord. From the trial court, my lord.
In the case that you withdraw because charge sheet has been submitted.
No, earlier case.
Item 11.
Other case.
Yes. In that case, he had prayed for anticipatory bail. In this case, he is praying for anticipatory bail. Where is the assurance that you will not be again indulging?
It is a prima facie. When case is charge sheeted, I am not in the charge sheet. It means that I am innocent person. Otherwise, I could have been named in the 33.
Allow it. We'll allow it. Huh?
And that review will be this. Nazim also will be on the ladies.
Is I not here? CD not here?
Nazim will be. Sasindra will this.
Tell us, we can wait for the CD, grant him an interim.
Interim may be granted, madam. And case diary, if reveal, madam, mail will reject, madam.
Find out, add to.
But the charge sheet is not submitted, I am confirmed.
That is, add 2. He wants some time till 2. He wants some time till 2 at 2. It's another 1.5 hours. 2.5 hours. আহিছে নেকি তেওঁ নাই আহিলে সুধিম মই লাহেকে দুইটা কেছ মানে তালে গুচি গৈছে মই তাতে মেনশ্যন হৈছিলে তাকেতো ভাবিছো মই আজি কেনেকে ফিক্স কৰিলো এনেকে পিটো লাগে হ'ব বেলেগ কন্টিনিউ কৰক লিষ্টখন আহিলে দেখা যায়
Supplementary idea, Petitions.
Your Lordship, connected item with item number 58, Your Lordship. 58 CD was called for, Your Lordship.
58, do you have the CD?
No,
Eh?
35 days behind the bar, Your Lordship. This is the case regarding transportation of, allegation is the transportation of 18 numbers of buffalo, Your Lordship. So otherwise purchased buffalo, Your Lordship, and these are the 3 persons are the helper and driver of the vehicle, Your Lordship, which has been used for the transportation of this buffaloes, Your Lordship.
Buffalo murder, buffalo killing is not murder inside the truck. One of the buffaloes died also.
Yes, died, Your Lordship. One of the buffalo died.
They are the driver and the helper.
Helpers of
And item 58 is?
58 is the purchaser of the owner of that buffaloes, Your Lordship, and one is the owner of that vehicle, Your Lordship.
Any interim given in that, or they are also behind bars?
58.
58 to the action.
Item number 50.
Oh, yeah. 58. Connected bullies. CD not received.
I'm not on interim, your lordship, in this case, that
Huh?
is 66. I'm not on interim, your lordship.
On this 58, item number?
58.
58. If we allow the interim to the purchaser, allow him to produce all the documents, allow you some time to come back with the CD. On the next date, if the buffaloes were lawful and legal,
Now they are.
we'll allow him 3 days or 2 days to appear. At max till 20, we'll allow him to appear before the 28th. Today is 22nd, 21st. 27th or 28th. The owner will fix it on the 4th. We'll fix it on the 4th. Verify the authenticity of the documents given by him. If they are lawful and legal, we'll consider all of them together.
Yeah, lordship.
Will that do?
Can be fine, your lordship, but petitioner number 2 is the owner of the vehicle, your lordship. So he rented his vehicle to the petitioner number 1, your lordship, after verifying or after knowing that they had been legally purchased, your lordship. So that may be granted to petitioner number 2 also, your lordship. My humble prayer, your lordship. Because the cruelty part doesn't attract the punishment. That is only fine, your lordship. Confined to only 10 rupees, 50 rupees, fine, your lordship. So my humble prayer to petition number 2, lordship.
Item number?
The driver, if animal, there should no malad. 18 buffalo, 1 died malad.
It's a truck, your lordship.
The truck, how cannot they figure out this?
It is said.
In one city where a photograph in other case, malad, 6 cow died. Out of perhaps 22 or something, he died. So the ties are very bigly in keeping.
They must be having professional driving licenses. Confiscate that, cancel it out.
This not time I'm not paying for.
A takedown in 58.
58 AB, your lordship.
This is an anticipatory bail petition. Praying for grant of pre-arrest bail in connection with Dharmatul PS case number so and so. Page 2 to say. So and so. Stop. The petition number 1 claims to be the owner of the cattle, and petitioner number 2 claims to be the owner of the vehicle in which they were transported. The learned counsel for the petitioner has submitted that although the CD had been called for by the order dated 812026, the same is not yet available. Full stop. The learned counsel for the petitioner has further submitted that given an opportunity, they would be able to produce the relevant documents relating to the purchase of the cattle which was being transported. Full stop. In view of the submissions made, this court grants the liberty to the petitioner number 1 to approach before the investigating officer of the said case within a period on or before 28th of January 2026 to produce the necessary documents in his support and also to have his statement recorded. Full stop. It is provided that in the case of his arrest, he would be released on bail of on bail on furnishing a bond of rupees 20,000 with 1 surety of the like amount. Stop. The petitioner number 2, who claims to be the driver of the vehicle, shall also, who claims to be the owner of the vehicle, shall also produce or shall also be at liberty to produce such materials to show that the vehicle was given out on hire without knowledge that it could be used for such. What do you say? What do you call that? to transport 18 buffaloes in the truck, full stop. It is also provided in the case of his arrest, he shall be released on a bond of AKD. So, list this matter again on the 4th of February 2026, along with the updated CD. Full stop. It is the interim protection has been granted only to facilitate the petitioners to produce their documents and to have their statements recorded, and only to do this. Full stop. In the other one, you write down.
Much obliged.
List again on 4th of February along with AB number so and so, where the case diary has already been called for. On the 4th of February, we'll have both.
Much obliged, Lordship.
67.
May I please, Your Lordship? Lordship, it's a case of abetment of suicide. However, the allegations level in the affair do not attract any ingredients of section 108. My Lord, will you please to find the FIR at page 10. FIR at page 10. May I read? My Lord, it is true that they got married through a court marriage, but they didn't cohabit at any moment. At a very they were of the same age, at a very tender age, at the age of 20 years, because of the love affairs, keeping secrecy from the family members, they have done the marriage registration. Thereafter, though this lady, the deceased, said that, my Lord.
Let us have the CD.
My Lord.
Only because that lady has used a syringe and empty vials and all that.
Yes, she is a nurse, my Lord. So she has the access of that.
So whether there was some pressure from your side, some refusal from your side after this long side or not, which may have led to her taking decision.
Nothing, my Lord.
16, so he has come up with something. Page 16. What does he do, this petitioner?
Nothing, my Lord. As because he couldn't establish himself, the parents didn't, the case is vice versa. The case is the opposite exactly. The parents didn't allow her to get married with that boy. This allegation is from the parents itself.
Yes, how soon? How soon? We'll have it on. It will refresh করে দিব দে এবার এটা এবার refresh করে দিব will can we have it on the either the 2nd or the 9th?
My Lord, 2nd, my Lord.
2nd. Mr. Swensel and Counsel. So the also the learned PP application under section 483 for granting regular bail to the accused petitioner who was arrested on 312026 in connection with Soigao PS case number 02 of 26 under section 108 BNS 2023. Call for the case diary list again on the 2nd of February 2026. If they have not stayed together, the abatement part, I don't know.
They did not stay together. They considered them marriage.
So that point, how can they be abatement then?
Exactly, my Lord.
Let us see. Yes, what is this?
Much apology.
13.
May I please, Your Lordship?
Hmm.
And the allegation with regard to the abatement and the FIR is at page number 20. This is a translated copy of the FIR.
20.
Yes, Lordship. And this FIR, the incident took place on 22/11/25, and after 5 days, the FIR has been lodged and the petitioners have been implicated in this particular FIR, and there is no explanation with regard to the delay. Now I'm just reading the FIR. If Your Lordship kindly see the contents of the FIR. With due regard, this is to inform you, sir, that my husband, late Mohan Gogoi, was running jointly Shadia Indian Service along with Bokho Gogoi and Lokhin Chetia. In connection with the business, Sri Lokhin Chetia and his son, Sri Manoj Chetia, were involved in cheating in financial transactions and also involved in mental harassment for a long period of time. Because of their conspiracy on last 22/11/2025, he had chosen to end his life by jumping into a fissure. Now, the petitioner number 2, the other person who has been named, the son Manoj Chetia, he is no way connected with the business, Lordship. He is not there in the business. He is a service holder. I have annexed a copy of the this appointment letter and is joining. He is a junior assistant. And the particular statement that has been made in the FIR without explaining the delay in lodging that FIR is not going to show that there is any form of direct or indirect inducement on the part of the petitioners to this for the reason the
Where is that suicide note?
Suicide note, it is not there.
It had come up for motion also.
Yes, Lordship. I am praying for the interim protection, Lordship, on 2 grounds. First of all, the petitioner number 1 is suffering from illness. I have been at that point of time, I could not place it. He has undergone surgery. There's a fracture in his thigh bone, and he's in a bedridden condition. And the petitioner number 2, Lordship, he's a serviceman, so he is otherwise no way connected, Lordship.
Service person. Service person. How, if he's arrested now, service goes. If the suicide note doesn't contain him. But then why would the wife name if their names are not there? How soon?
Lordship, kindly peruse the medical certificate also.
No. What is the date of his operation?
That was on
Surgical intervention.
2nd of February 2025, Lordship, not recent, 2nd of February. Lordship,
Doesn't-
I'm just referring to a judgment of the Honorable Apex Court. That means very specifically it has been mentioned in that particular judgment that I'm just reading that relevant paragraph, Lordship. This in 2010 8 SCC to 628, this court held that in order to bring out an offense under section 306, that was with regard to 306 IPC, specific abatement is contemplated by section 107 on the part of the accused with an intention to bring about the suicide of the person concerned as a result of that abatement is required. It was further held that intention of the accused to aid or to instigate or to avert the disease to commit suicide the must for attracting section.
Exactly the reason why we want to have a
No,
look at
Lordship.
the suicide note.
Your Lordship, can you see the contents of the particular FIR? In that particular FIR, it has been mentioned that involved in mental harassment for a long period of time.
That is only an information given by the wife.
Yes, Lordship.
Who would have no knowledge of the persons who might have been troubling him. Is it not? This information must have come.
That, Lordship. What I'm
must have come from
submitting.
somewhere. A perusal of the suicide note would show whether it was an abatement or whether it was just a business tussle or whatever it was, and he decided to commit suicide. That is what the suicide note would to some extent reveal.
Exactly. With regard
So
to
we
that
can have
particular
it-
suicide note, if the statement is there, that because it is reflection is there in the FIR, Lordship, that the Lokhin Chetia and his son were involved in cheating in financial transaction, also involved in mental harassment. And why he had not gone to police? Because if the statement is there for a long period of time, that was never been communicated to the police.
Why a man does not go to the police is something beyond us.
Exactly, Lordship.
It is beyond us.
Mere
will not
putting certain thing, and that is the reason why Honorable Apex Court has held it. The mens rea should be there. In absence of that specific mens rea, putting a person behind the bar or constituted interrogation is not otherwise required, Lordship. I'm ready to cooperate with the investigation, Lordship.
If you can wait till the 30th.
Lordship, considering my health condition, because this
health condition is
maybe,
not-
Lordship, this is an old certificate, but the person is 65 years of age. He is not in a position to move here and there, Lordship, because of this particular health.
He need not move. The purpose of arrest is to keep him without moving.
No, Lordship, the custodial part is there, Lordship. Some protection may be given he is ready to cooperate with the investigation in all possible forms, Lordship.
We wanted to have a look at that.
No, this
Not without 30th, we can accommodate you on 30th. We are not accommodating anywhere, any.
Then the
anybody.
petitioner number 2 may be considered, Lordship.
Huh?
He is a serviceman. I have annexed all the
Yeah,
necessary.
that is what we were asking.
Yes.
The petitioner number 2, a serviceman. Picked up now, he loses his job. Even thereafter, if we grant a bill, becomes difficult for him. Huh?
He has not been arrested.
Huh?
Even 30th, only 30th.
Well, the apprehension is always there, Lordship. So this protection is not going to hamper the investigation in any manner, Lordship.
2 we are considering for the time being. Heard Mr. SP Chaudhary and Counsel paying for the petition also heard the learned PP. This is an application praying for pre-arrest for the grant of the privilege of a pre-arrest bail to the petitioners in connection with Sadia PS case number 117 of 2025 under section 108 of the BNS. The allegations in the FIR are to the extent that the 2 petitioners who are related as father and son had abetted the suicide of the husband of the informant. Full stop. The FIR also refers to a suicide note which was attached to the FIR, but the same is not on record as of now. Full stop. What is this, page 23?
Page 23, Lordship, I just intended to project. Here in this case, these 3 persons were there. 3 persons with regard to this particular partnership business. And the petitioner and this deceased person, they had jointly filed one case against the 3rd partner. So they were having a very good relation.
Petitioner number what?
Petitioner number 1 and the deceased. And the 3rd partner was there. The allegation was against the 3rd partner.
Okay,
having
next item, next
like
item.
that. This
Call for the updated case diary, full stop. Updated case diary, full stop. A perusal of the suicide note would be necessary. Then on the next item, the petitioner number 2 appears to be a government servant. Has been not appears. The petitioner number 2 has been stated to be a government servant.
Yes, Lordship. I've annexed the document.
Who is presently posted at?
Junior assistant, Lordship.
As a junior assistant at?
Quizan Development Block, 302.
At Vision Development.
Page number 24.
Vision Development Block in Tinsukia. Good stuff. It is provided that in the interim, in the event of the arrest of the petitioner number 2, he shall be released on bail on furnishing a bond of rupees 25,000 along with 1 surety of the like amount, subject to the satisfaction of the arresting authority. Full stop. Further continuance would be considered on receipt of the case diary. For the continuance of the interim protection will be the petitioner number 2 shall also appear before the investigating officer before the next date fixed to have his statement recorded.
Appear before 27.
Shall appear before the investigating officer on or before the 27th of January 2026 to have his statement recorded.
Small prayer, Lordship, one observation. If the CD is not there, with regard to petitioner number 1, considering his health and the age.
The learned counsel for the petitioner has submitted that the petitioner number 1 is aged about 65 years and has undergone surgical intervention for a broken femur.
Lordship.
Broken femur. In the recent past, full stop. No, list on hey Luna, fourth list when was the date you asked for? 30 January. 30 January.
May it please your lordship, my lord. My lord, is a pre-arrest bail application. My lord, affair is at page 58. Type copy.
50.
58, my lord.
58.
Yes, my lord. With reference to the above, I am directed to request to kindly raise the case against the petitioner after seeing the then executive engineer Nalbari, and presently posted at AC, Superintendent Engineer Hailagandi, on reinstatement as per inquiry report submitted dated 28/4/2022 by the Deputy Commissioner Nalbari regarding misappropriation government money by so-and-so the 10 Executive Engineer PC Nalbari in the form of payment of false bills for construction of IHHL, individual household latrine, my lord, under SBM, Swachh Bharat Mission Gramin, and based on the fact and finding of the inquiry report of the DP dated 21/2/2023. My lord, my contention is that basis of lodging of the FIR are these two reports, my lord. The two reports, one is DP report of the department inquiry as well as the in-house inquiry. Now, my lord, on the basis that the report, departmental inquiry report, my lord, on that basis, I was dismissed from service. And that dismissal order annexed, my lord, dismissal order, my lord, lordship will find at page 29. Page 29, my lord, third paragraph. This is updated 14/12/2023. And whereas as per the report of inquiry officer, I was found that there was misappropriation of government money implementation as SBMG in different Gao Panchayat and Belsor PSC division in connection with the work order payment of bill construction. And like for this inquiry done, on that basis, dismissal order was passed. Now I challenge this dismissal before the Honorable Court. The Honorable Court, my lord, this order is at page 31, my lord. That entire thing has been set aside, my lord. Inquiry report, para 16, page 40, my lord. Because in-house inquiry, I was not given any opportunity. Finally, this was the termination order set aside and director for face inquiry. Face inquiry as of date not conducted. My lord, I was reinstated in service 42, page 42, my lord, 24/4/2025. Now I have been posted as Superintendent Engineer, my lord, as Hailagandi. Now, the thing is that, my lord, since the basis of the reports which have been interfered and directed for face inquiry, my lord, the allegation level in the FIR perhaps is not attracted, my lord. And moreover, I am a service holder, my lord. I have been already transferred from Nalbari to Hailagandi, my lord, on reinstatement. And there is no scope for, my lord, tampering with the evidence and the influence of the witnesses.
What is the bill, my lord? Actually, then he has appeared.
Yes, I appeared. Yes, I appeared also. Yes, yes, I have an ex.
Huh? Page?
Page 79, my lord. Police call me, I appeared.
So why is the appearance?
No, ma'am, apprehension is that, my lord, I am retiring by February. But these days are going, my lord, this way that anytime I may be arrested. So that's what. And the report is, my lord, page 80. Page 80, my lord. I appeared.
Huh?
Now, my lord, I am retiring by February, my lord. That the statement is there. In fact, in the order itself. My lord, page 41, my lord. Para 17. I'm retiring by February 26. My lord, for these 2 days, my lord, 30 days, it is happening, falling on my head, my lord. And they are calling, I am.
Yes, PP.
No, we are appearing.
Or you will appear.
Some protection service holder, my lord, he should. Yes.
He has already appeared, you have not arrested.
Yes.
Where is the appearance?
No, I have stated with yes, para 11, my lord. Last part. Part of the petitioner states to
we will call for whatever CD you have. Until such time he don't arrest him. If you have not arrested,
yes,
don't arrest him.
yes.
This petition is still not admissible. Where is the
No. I have, therefore I have come.
He is absconding, we are cutting him, that is not a case. We have issued notice, he appeared. He cooperated, our statement has been recorded. Now, the investigation will continue, by the seizure will be made. So where is the question of apprehension?
For whatever reasons, if he's
arrested
detained now,
my lord.
his entire pension and everything will
Yes.
be even before he is found guilty by the. See, we would not have gone to that extent. It is only because the department was given the liberty to take up a fresh proceeding, they have decided not to. There can be two reasons. We don't need to now. He is not guilty, or jo hua so hua. let him retire in peace. One of the two
Yes,
attitudes
yes,
had come in
correct.
mind. If someone has that attitude in mind and all he's praying is for an anticipatory bail at this point of time, during the investigating period, once the investigation is over, he has to go for a fresh regular bail with the charge sheet is filed. The moment we reject this,
We are not rejecting it.
he will.
I will say that this putting dispositive.
Because police,
Yes.
no, Mati is set down.
This call for because what's happened been recorded.
If,
He could have the very day he should have evidence.
Man, Sacit can be filed after arresting only. That's the problem. And this is the stage, my lord.
35 3 your lordship may kindly. BNSS. There is a notice under 35 3 man.
So it says that once the person appears, there will be no further arrest.
Yes, also. Police officer in all cases, when arrest of person is not required. 35 3 of the BNSS. The police officer said in all cases where arrest of one is not required under chapter 1, issue notice directing the person against whom the reasonable complaint is to be made. The relevant information received. Reasonable suspicion has been clear from the complainant offense. To appear before him, as such other place. When that notice is issued, it will be duty of that person to comply with the notice.
Yes, yes.
And when such person complies and continues to comply with it, he shall not be arrested. So where is the question of arrestment?
Unless.
So he's appearing.
Unless.
In his own step back, his stand here, second, and he has been appearing.
It's hard, Mr.
Mal. Some protection requirement.
Heard Mr. B.K. Das, Learned Counsel appearing for the petitioner. Also heard Mr. Learned Special PP. The petitioner, and this petition started like this. This petition has been filed apprehending arrest in connection with Vigilance PS case number 11 of 2025 under section 120. Take it from page 2, huh? The case of the petitioner is that although earlier he had been dismissed in a disciplinary proceeding regarding to the same allegations, the disciplinary proceeding had been interfered by this court, and the disciplinary authority had been given the liberty to proceed in a fresh disciplinary proceeding within a period of 6 months of the date of passing of the order. The Learned Counsel for the petitioner submits that no fresh departmental proceeding has been conducted. Full stop. The Learned Counsel for the
That has been stayed, my lord. That order is there, my lord.
Cut out that last line. The Learned Counsel for the petitioner has submitted that the fresh department proceeding initiated against him has been stayed by orders of this court. Full stop. The Learned Counsel for the petitioner has submitted that the petitioner is slated to retire from his services in the month of February 2026. Full stop. The Learned Special PP has referred to the notice under section 35(3) of the BNSS and has submitted that the petitioner has already appeared before the investigating authority as required under law and he was not placed under arrest at any point of time. Therefore, the apprehension that he may be arrested in connection with this case is perhaps not well founded on any, is not well founded. Full stop. Call for the case diary. List again on. When can we have it, Mr.? We'll have it on the huh? On the 12th of February, 2026. Stop. Keeping in view the submission made by
in the meantime, my lord,
we are recording this.
No, my lord, that's correct, my lord. Apprehension, my lord, there's the government person.
In the meantime, it is provided that
the fake on the service
in the event of his arrest, the petitioner shall be 25,000.
20,000.
One surety of the like amount, subject to the satisfaction of the arresting authority.
Deeply.
Let him retire in peace.
Yes, ma'am.
If the disciplinary proceeding succeeds or if the
there should fresh FIR
succeeds. In any case, he loses everything.
Yes.
Is it based on, based on article?
No, that is what I'm saying. Either if he's trapped in either, entire thing goes. Let him retire in peace.
That's why we allow him to go.
The next is the PP, that is the provisional pension during pendency.
It will continue for the pension. Obliged, my lord.
Yes,
Deeply
next.
obliged.
Next.
Thank you.
My lord, this is an application for pre-arrest bail. Lordship, kindly peruse page number 9, the FIR, my lord. And the original is in page number 14. The gang of, my lord, miscreant young boys, my lord, they attacked one advocate. To save him, his neighbor came and they assaulted him and subsequently he died, my lord. This is a very sad story. And ultimately, I find, my lord, there are 10 boys have been arrested and produced before the court, my lord. They are under jail custody now. But so far this petitioner is concerned, she's a mother and the police came to look for her son. His name is Ashik Rahman. His name is Nohe. She came to search for that person, Ashik Rahman. They could not find Ashik Rahman. Now they want the mother, my lord. She said being harassed. That's why the application has been filed.
Yes, sir, the mother.
He doesn't stay with her also. With that.
That is another aspect.
Like he might.
2 persons have died.
15. No, in the forwarding report, I find 1, my lord. Can you have a look at once? In the FIR, shown 2, but in the order of the Lord Magistrate, I find, my lord, 1 person. And 10 persons is may arrested. But this is very unfortunate. I think it was a birthday party, my lord. And these boys gathered together, had alcohol, and then, my lord, they assaulted an advocate.
Those persons are a different issue. The mother of one of the accused, we are granting it. Yes. Heard Mr. So-and-so and considering senior counsel. Appearing with the assistance of Mr. So-and-so and counsel for the petitioner, also heard the already PP. The allegations in the FIR level, the allegations leveled in the FIR are that some quarrel took place in the house of an advocate. And when the deceased had tried to intervene, the gang had beaten the person to death, full stop. The senior counsel has submitted that around 10 people have been arrested during the investigation. And this anticipatory bail petition has been preferred by the mother of one of the suspects. Apprehending that she may be arrested since her son is presently not being traced out by the police, full stop. Call for the case diary. In the interim, it is provided that in the event of the arrest of the petitioner, she shall be released on bail on providing a bond of rupees 15,000 with 1 surety of the like amount subject to the satisfaction of the arresting authority. We don't require her to go and give any statement. That is what, do we need her to go and give a time frame? Her son went outside, they beat up someone and that fellow died. What statement would she give? The petitioner would appear before the investigating authority on or before 2nd of February.
Yes, it's all right. It's all right, madam. She will go.
List again on 9th of February? No, you go for one few days after 12th of February. You can take this back, sir.
Yes. Obliged, madam.
Item 16.
Well, can it be taken at 2 p.m. Little documentation only?
2 p.m.
Lordship.
17.
Next page, Your Lordship.
Mm-hmm.
Fire is at page 15.
Uh-huh.
Fire is at page 15, Lordship.
1-5.
1-5, Lordship. To Mary.
Lordship, in this matter, Lordship, the accused number 3, the applicant before your Lordship, he is an employee in the senior superintendent office of the Majuli. Lordship, he is an LNK and appointed as a constable LNK in the senior superintendent. And at that point of time, when the incident was occurred, he was not present in the place of incident, and he is falsely implicated, and he was in the office, and if your Lordship see that on 6 he was on duty from 1 p.m. to 6 p.m. From his office and from his office to his place of occurrence, it will take more than one hour time. And moreover, Lordship, he has appeared before the Bongaon police outpost before when the investigating officer conducted his preliminary inquiry, Lordship.
Preliminary inquiry is going on.
Yes, I have appeared in the preliminary inquiry. Then after Bongaon outpost, the FIR was lodged before the Bongaon outpost. Then after it was sent to the Majuli PS and registered as the Majuli PS case number 3. So during the preliminary inquiry,
You were on duty from 1 to 6.
Lordship.
You were on duty from 1 to 6.
Yes.
Incident occurs at 7.
7, Lordship.
Within Majuli, which place takes 2 hours?
More than 1 hour, Lordship.
Within Majuli itself?
Lordship. His
Largest
office,
island, no?
His office.
Largest river island, so it may
Lordship.
take some. Yes. Yes.
See, and Lordship,
When was it? 9/1.
Lordship,
Just one thing I would like to. This is lodged on 7/1. Incident is of 6/1. If you have page 24, 8/1, see, then you will see the second person. He was on duty, he has signed. On 9/1, he has signed. On 10/1, he has signed. So he has been attending his duties within the same police station, or at least somewhere else.
Lordship.
He has not been arrested till now.
Lordship. So, 2 accused first.
There is a job.
Lordship.
That is what.
Lordship.
Any involvement found by a police officer?
Lordship.
What is that sentence? Going on with a. We'll tell. He has appeared in the preliminary inquiry. Heard Mr. So-and-so counsel appearing for the petitioner. Also heard Mr. Bisham the APP. This is an anticipatory bail petition praying for grant of pre-arrest bail to the petitioner in connection with Majuli PS case number 3 of 2026 under section 302. Page 1. The counsel for the petitioner has submitted that a preliminary inquiry has been conducted into the incident by the department itself where the petitioner has appeared and participated. Full stop. The counsel for the petitioner has further referred to the duty charts annexed to the petition to show that the petitioner has been continuously discharging his duties prior to, on the date of and even after the date of the incident. Full stop. The counsel for the petitioner therefore submits that the petitioner that the custodial interrogation of the petitioner may not be necessary for investigation into the case. Full stop. The learned APP has objected to the same, saying that being a police personnel, there are serious allegations against him, and certain acts have also been attributed to him in the FIR. Full stop. Call for the case diary list again on the 13th of February 2026. Stop. In the interim, it is provided that in the event of arrest, the petitioner shall be released on a bond of rupees so and so. rupees 20,000 with one surety of the like amount. Further continuance of the protection granted shall depend upon the shall be decided on receipt of the case diary. 13th or 12th? 13th of February. List again on 13th of February. 12th of February.
Deeply applied.
For this one, item 18.
Lodge.
Yes.
The challenge hearing this petition is the Lordship impute order whereby Lordship learned trial court has declined to Lordship discharge this petitioner from the charges of Lordship 138 NI clause. The basic case is that Lordship, this respondent number 2, she has lodged a complaint Lordship under section 138 of the NIA and notice was issued to these petitioners. Accordingly, Lordship, this petitioner appeared before the trial court Lordship and submitted an application that Lordship will have the application at page 37.
Are we only admitting it today or are we disposing it? They have not appeared.
Yes, Lordship. Can admit it or Lordship.
We'll continue the interim?
Lordship.
This is of when? 25.
Yes, 25.
What are your grounds?
Basically, Lordship, we have no legally enforceable debt Lordship to pay any amount. That has been Lordship, we have submitted all those documents also. And prior to lodging this complaint petition.
Which order have you challenged?
That at page 39, Lordship.
39. You say you had given those checks as a security.
Lordship. And that was not they have contended that Lordship, the check was issued on September 2024. Wherein Lordship, we have issued that given the check in 23 at the time of Lordship taking loan of rupees 1 lakh. And we have repaid the loan around 80,000. 20,000 left Lordship because of illness of a son.
That is the civil part of it.
Yes.
Just tell us whether if you have admitted the issuing of the check.
Yes.
And if you state that it is on the basis it was a security.
Security check.
Whether NI Act can proceed against you or not. No.
No, basically no. Because they have contended the check was issued on September 24, but prior to Lordship that we have lodged a complaint before the Lordship additional superintendent of police Lordship Bongaigaon to Lordship recover our checks and all Lordship, which was supposed to they misuse that check Lordship.
But Mr. J. Kolital and counsel for the petitioner also learned APP is also present. Non-APS for the respondent number 2. Stuff admit.
Sole respondents.
Huh?
Sole respondents. Lordship respondent 2. That is there.
Respondent number 2.
Respondent number 2.
Admit interim order to continue till the next date. List on its turn.
That is interim that will continue.
Interim will continue, list the matter on its own turn. Or should we fix a date? Did you?
After 4 days or 3 days.
Huh?
After 3 days.
List again on 24th for discussion. 24 February.
Obliged.
Till 19.
May I please, your lordship? My lord, the petitioner herein challenges a proceeding, which is basically a.
You have a copy?
Yeah, I have filed the evidence and
Affidavit.
Objection.
Yes.
The petitioner, my lord, petitioner number 1, he was in possession of a Taxonia plot of land, my lord, government plot of land, my lord. So the opposite party approached him, my lord, and he then, my lord, by executing a instrument.
Can we admit this and have it for disposal?
Yes, my lord.
We'll admit this. There is already an interim.
Yes, my lord.
We'll admit, fix it in the last week of February.
Yes,
Take
my
it
lord.
up for disposal. Heard Mr. Deliberal and Counsel appearing for the petition. Also heard Ms. Swensel and Ms. P. Sharma. And a counsel for the sole respondent who has submitted that an affidavit in opposition has been filed on the 9th of January 2026, full stop. Having heard the learned counsel for the petition and on going through the records, admit this petition. List again on 25th of February 2026 for disposal.
My lord, interim order may continue.
Interim order passed earlier shall continue.
Obliged, my lord.
20.
Forest.
By previous lordship, in this case, my lord, TCR has been
Huh.
shipped. And otherwise.
But
matter
the
is
holder
ready
of
for
the TCR,
disposal.
yes.
I have got to my lord scan copy.
Hmm.
That my lord, the last order is of my lord.
26.
That is 4925, my lord. My lord, that is for appearance at the court. And my lord, that report is my lord, which was necessary because my lord, with the bordering area land, my lord, my lord. I think my lord, update copy of the my lord scan will be there.
Are we on the same case?
My lord,
Are we on the same case? This is item number 20.
20 yes, my lord, criminal petition 1037. Of 25.
Heard Mr. Swensel and counsel appearing for the petitioner. Also heard Mr. Swensel and special
Number.
standing counsel forest. Full stop. The learned standing counsel for the forest department has submitted that a copy of the
My lord, I am appearing for the respondent to my lord.
ordinance
Scan copy I have sent to my lord.
has submitted that.
This order, my lord, kindly have a look at my lord, the last order, my lord, 4925, my lord. This is only for my lord appearance and report, my lord. And that report, my lord.
Of 49 of what? The the TCR.
Yes, my lord, LCR.
You are still continuing with LCR.
My lord, I have gone to my lord.
You should shift to TCR from LCR. Huh?
My lord, during this period, my lord, some development may be there, my lord.
49, they are transmitting it to us.
25, my lord.
4925, they are transmitting the records to us.
Yes, my lord, kindly have a look at the previous order, my lord. Previous order of that, my lord.
For appearance oblique report.
And report. That
Huh.
report is, my lord, very much, because my lord, the bordering area, that land is disputed land, my lord. If it is belongs to my lord, Arunachal Pradesh, it is okay, my lord.
There is interested under dispute.
In our opinion, my lord, it is the land of, my lord, Assam land. And
Yeah.
my lord, it is the cutting and digging, my lord. This is my lord, forest domain.
It is their allegation, my lord.
The learned, you are standing counselor?
My lord, specifically.
The learned special public prosecutor has submitted that the report referred to in the order dated.
Up to that, can be totally suffice. If any report is, my lord, furnished.
That the report referred to in the order dated 27/8/2025 in CR within bracket F 15 of 2023 would be necessary for a proper adjudication of this matter. He therefore praised that as updated scanned copy of the trial court report record of the events occurring after 492025 and along with the copy of the report, if available, be called for. Full stop.
Only one thing, my lord. Otherwise, this honorable court has stated the further proceeding by order dated 26/8/25. 26/8/25, my lord. So in that.
So the report may not come.
May not come because after 26/8, there may not be occasion.
The learned counsel for the petitioner has submitted that the further proceedings in the case had been The further proceedings in the aforesaid case had been kept in abeyance by order dated
26/8/25.
2025. So where from the report will come? Who has to submit the report? You are appearing for the Forest Department. The learned special PP for the Forest Department shall procure the copy of the report and place it on record for further adjudication of the matter. The special PP may furnish a downloaded copy of this order to the department for further needful.
May it come up in the month of February last week?
List again on 26th of February 2026. 26 to 2026. Interim orders passed earlier shall continue.
Published.
It is your report and you are saying I should call it TCR. Why? It is your report. Why should I call why should I call a scan copy from the TCR?
By the learned court, man.
Huh?
By initial order.
By the initial order. So I have to think that.
Otherwise, the petitioners always take the chance. Let the court call it. Let me not spend. You are the department itself. Yes, next. 21.
In this case, record was called for, scan copy of the record, but perhaps it is not there.
TCR has not yet come.
I have also filed a rejoinder affidavit. That is also not on record. The matter.
When did you file it, sir?
Today.
Because I have got this, anyway, my parents, they could come on the first week of February.
First week of February, a little tied up. This is 21. Item 21, CD is available. Heard Mr. I. Saikia, Learned Counsel, appearing for the petitioner. Also heard Mr. R. Saikia, Learned Senior Counsel, assisted by Ms. So-and-so, appearing for the respondent number 2. Mr. Sharma, Learned APP, has submitted that the CD as called for by the order dated 10/12/2025 has been received. Full stop. Mr. Saikia, Learned Counsel, appearing for the petitioner, has submitted that he has filed an rejoinder to the affidavit in opposition filed by the respondent number 2. The said rejoinder is not on record. Full stop. List again on 12th of February.
I have worked with they are everything. I am ready to adjudication. Let it come there on the next week, my lord.
The earliest date that we can afford you is 11th or 12th of February, sir.
Okay.
11th of February will do? Yes.
Yes,
List the matter again on 11th of February along with the rejoinder affidavit. Stop. In the admission column. Stop. The learned APP shall send back the case diary received and requisition and updated CD on the next to be produced on the next date.
May I please, your worship, on 17/12, I have paid for filing of an additional affidavit. But somehow it could not be filed because of non-availability of one of the directors. So it will be filed by tomorrow, your lordship. The matter may
Mr.
come
M.
up on
Sharma, Learned
27th.
Counsel, appearing for the petitioner, has submitted that a short accommodation be afforded to enable him to file the additional affidavit. Stop. List this matter again on the 2nd of February
Your lordship, on 2nd of February, I have this matter in the lower court. So 27th may be given, 27, 28. Maybe, yes, sir.
On the 30th of January 2026, along with the additional affidavit proposed to be filed. Hello. 22, 23. Yeah.
May it please, your lordship. My lord, this application has been filed.
TCR to ahise ne?
Yes, my lord.
Huh?
They received, my lord.
CCR received বুলি কৈছে, আহিছে।
But it contains only order
Huh?
sheet, but it contains only order sheet and my lord, FIR and search sheet only, my lord. No other documents are there, particulars are there.
What more is required to be?
Here, my lord, my main contention is that there is no incriminating materials against the petitioner
Huh?
in the, my lord, case records, as well as, my lord, the particulars furnished to the petitioner.
To evaluate that, the charge sheet would be enough?
That may not be enough, my lord, but I have already annexed, my lord, 161, all the statements, 161, my lord. And my lord, after going through the 161 statement of all the witnesses, I have found, my lord, only some statements against the petitioner, my lord, that is stated by the informant only. No other witnesses even mention the name of the petitioner, my lord. And no facts has been, my lord, stated by any witness regarding involvement of the petitioner in any alleged offense, my lord. The lordship may first peruse the FIR, my lord. Here, my lord,
and the first reading order has been rejected. Go to the picture has come.
Sorry?
Picture has come. The first reading, the order has been rejected. We have to go to the
My lord.
What has been rejected? Charge framing?
My lord, we have filed one discharge petition in the case. That has been rejected. And
That has been.
and my lord, thereafter, charge have been framed, my lord. We have challenged both those orders.
Where is the FIR?
My lord, FIR is at page, my lord, 22. I am Atul Kumar Das, my lord.
Page number?
22, my lord.
23. 23?
22, my lord.
We will admit this and take it up. When is the next date fixed?
Yes, in the next date is, my lord, on 8th April,
8th April.
my lord,
We'll take it up in the last week of February.
my lord,
Here and dispose it of.
my lord,
Unless you show us
my lord,
that the
My
trial should not proceed.
my lord.
Whether there is something against you or not is for the trial court to see, not for
No,
us to see.
But my lord, the particulars furnished to the petitioner under 207 of CRPC, my lord. Those are the materials proposed to be, my lord, adduced during the time of evidence, my lord. And there is nothing against the petitioner. If those particulars remain unrebutted,
Where
then
is
also,
that?
my lord, no conviction is possible, my lord.
And that we will consider on, it's on April. Prior to that, we can hear it and
My lord,
discuss it off.
my lord.
Heard the learned counsel for the parties, the trial court records have been received, which contain only the orders passed in the case and the, what does it contain? You said it contain only some things.
My lord,
PCR, what does it contain?
it is charge sheet and FIR.
The charge sheet and the FIR, full stop. No other materials have been sent along with the record, full stop. List this matter again on February. February. On 24th of February,
My lord.
2026.
My lord.
Full stop. The learned trial could be for further consideration, go to Bakil Analogous. Yes, next.
Supplementary item 68.
May I please the lordship?
PCR island?
In this case, TCR was called for, but not is
Heard Mr. Swenson and counsel appearing for the petition also heard the learned APP. The TCR as called for by the order dated 24/10/2025 and the order dated
12/11. Rejoinder was prepared.
12/11/2025 have not been received and the office note the office the office notes reflect that steps were taken on 21/20 that
Respondent said affair, my lord, on last October.
no, I'm seeing when was the last. This note reflects that. I'll cut out that line, cut out the office note, full stop. Issue reminder to the learned trial court to send the records by the next date fixed. List again on 17th of February 2026.
Before 16, if possible, my lord.
For 16, 12th of February 2026. 17 minutes, 12th.
Obviously.
69.
May please, your lordship. In this case, TCR was called for, as well as case diary was called for. There are two police stations, madam. There are two police stations. One Nemuguri PS case number, who is renamed as session case number 4.
The TCR has been received.
Yes, my lordship.
What is to be done today?
CD for Simoluguri PS case number 24/24. Simoluguri PS case number 24/2024, where case diary was called for.
Case diary,
That is not this.
call for the scanned copy of the records of the session case as well as scanned copy of the case diary of Bokota Nemuguri PS case number and Simoluguri PS case number, yes.
Yes.
Whether Simologro succeeded or not. Scan copy of case diary of Bokota and as well as the case diary, yes. Simologro case diary.
Heard Ms. Swenson and counsel appearing for the petitioner also heard the learned APP. The trial court records, scan copy of the trial court records have been received. However, the learned APP submits that the case diary of Simoluguri PS case number 24/2024 is yet awaited, full stop. List again on 12th of February 2026, allowing the learned APP to requisition the case diary of the aforesaid case.
Item 26.
Wait.
Otherwise, my lord, if your lordship have a look at page 17, my lord.
Page 17?
17, my lord. And lordship will see, my lord, Union of India, my lord, versus, my lord, Debasis Pal, Motiur Rahman. My lord, this, I am for Debasis Pal, my lord. And this Motiur Rahman, number 2, and the next page, my lord, number 3, my lord, Chadekul Haq, my lord. They were granted bail by this court, my lord. And that order I have annexed, my lord, at page 53. Page 53. 53, let me complete more coil on that. I should put 53 and 59, the two orders, my lord. On the ground, my lord, that notices were not supplied, my lord. Notices are not given, my lord. Same ground, my lord.
That was because of 47.
Yes, my lord.
And in your case?
Here, my lord, that 47, my lord, that originally it is 50, my lord. Section 50 of the CRPC, my lord. That your lordship will find at by page 52, my lord.
It is of the same nature.
Same nature, same.
It has to be in the same case, they will be issuing the same sort of.
Yes,
thing.
my lord. 52, my lord, lordship will see, my lord, that notice, my lord, no detail ground, and 50A, 50 capital A, not given, my lord.
Date of arrest is?
Date of arrest is, my lord, 2/3/24.
3/3/24.
24.
What was the cutoff date? For
2/3/24.
applicability of these cases?
These orders were passed, my lord, on, my lord, 15/5/25, page at page 53, and another one, page 59, that is, my lord, 30/07/25.
Pankaj Bansal is of 23.
Yes.
Okay, Yes, how do you support this notice under 50? We'll have it tomorrow, sir. We have got a basic idea. We can just hear him tomorrow and decide. At the request of the learned counsel appearing for the NCB, list this matter again tomorrow. The the learned counsel for the petitioner has been heard at some length.
I'm applied.
27.
That is your lordship. CD was called for. I am on interim bail, lordship.
Heard Mr. So-and-so learned counsel appearing for the petitioner also heard the learned APP who submits that the CD is awaited. List again on 11th of February 2026, allowing the additional PP to procure the case diary. Interim protection granted to the petitioner shall continue till the next date of.
Small prelude. Earlier on 4 occasions, this is 6th occasion, lordship. CD not received. So kindly next date.
Next date to do what?
CD not.
If the CD does not come, then?
Pardon, lordship?
If the CD does not come on the next date,
Again on next day.
then what do you do?
It's lingering, lordship.
Ah.
Several occasions there. Kindly.
Yes, Mr. Sharma, don't let cases linger.
Much obliged, lordship.
Until 28.
TCR is received, but service is awaited since long, lordship. So may I propose to take a fresh step, lordship?
This is item?
Item 28, lordship.
28. What has been received?
Service report is awaited on the response number 2, lordship. It's a Poxco matter, lordship.
Oh.
So may I propose to take a fresh step, lordship, again?
The service report on the respondent number 2 has not yet been received. The scan copy of the TCR has already been received. The learned counsel for the petitioner has sought for the liberty to take fresh steps on the respondent number 2. Prayer is allowed. Fresh steps be taken in notices be issued as per the prevalent notification. Steps within 3 days. List again on 13th of February 2026 for service report on the respondent number 2.
I'm blessed.
29.
Nothing in the TCR, no section of nothing. The pages of the orders.
When I.
One executive statement.
Huh?
Even the one executive statement is not there.
We'll have to call for the complete set of the TCR.
My lord, this is not a good case, my lord. Going by the FR, my lord. To be fair enough, my lord. Only my ground is that, my lord, section 48 notice was served or not. That
that notices were served or not, my lord, that specific information may be called for, my lord.
Heard Mr. Swenson, Counsel paying for the petition, also heard the learned APP, the scan copy of the DCR on perusal shows that it does not contain, no, that it may not be containing the entire record. We'll stop. Registry to inquire from the learned trial court as to whether the entire TCR had been sent. And if not, the entire scan copy of the TCR maybe should be forwarded to this court before the next date fixed. The learned counsel for the petitioner has submitted that the issue of the issue whether the notice under section 47 48 of the BNS had been appropriately served upon the relatives is one of the vital issues. Stop. List this matter again on the 13th of February 2026, by which date the learned trial court shall ensure that the entire TCR is placed before this court. Scan copy of the entire TCR is placed before.
That has not been received.
Going for short date, my lord.
Huh?
Otherwise, if there is apparent violation of 47 and 48.
When was the arrest?
Arrest, my lord, it is already, my lord, 1 year, 5 months. He was arrested on 18/8 to it's charge sheeted case. Charge sheeted.
When was the arrest?
Arrest on 18/8/2024. Lordship may kindly say page 18.
One more clarification will be necessary.
There is a 47 notice, it was mentioned.
Already the 3 monthly statement has been recorded.
Huh.
It is at the last end of the trial also.
Huh.
That is not clear whether trial has.
No, I've annexed a copy of the order sheet.
Hmm.
So already prosecution witness is completed. Now.
313 has been finished.
Yeah.
313 has been done.
Yes.
No, my lord, lordship may kindly see the last order, my lord. I have annexed the copy of the order. DW. He denied the allegations and now, my lord, this is, defense statement has to be recorded on defense witness has to be, my lord, adduced, my lord.
You can go from.
Yes, adjournment have been taken, my lord. My lord, may kindly come to page 52, my lord.
Just a minute.
Last date was supposed to be 12th of December 25.
25/9/2025, DW1 accused is examined and discharged after cross-examination.
Yeah.
On 25/9.
Yes.
Thereafter,
I have checked, my lord, the case status. It has been found on tomorrow, my lord, on 22nd, 1/2026. It is fixed for DW again. So DW has not been. Because 313 statement might be recorded. He denied. So thereafter, my lord, that.
no, what we do?
So what
today?
I'm
Tell us.
praying, what I'm praying.
For
What I'm
today?
praying, my lord, since 47, 48 has been violated, apparent violation. Lord, may kindly come to page 18 and 19 once, my lord.
Page 18 and 19.
18 and 19, my lord. 47 notice and 48 notice, my lord. No ground, no, my lord, nothing has been given.
Right, only there is a judicial order calling for the case that is verified suspect. That is why the case that is called for. Scan copy of the case. That is not the issue.
What is the date of this notice?
Notice, my lord, is 18/8/24, my lord, 47 notice,
28/24.
24, my lord.
4/11/25. This is fine. The violation is there, sir.
Yes, my lord.
Violation is there. 47, 48. Nothing is there. Tomorrow is the date.
Yes, my lord. At least, my lord, he has right to defense, my lord, at least, my lord. Let him try, my lord.
Huh? He is praying for the case diary. Do you by, can you by any means dispute this? The case diary is fine.
Yes.
When you say rightly or wrongly, we say okay, the case diary is fine. But if these are the correct pieces of paper, it will be there. The case diary will contain only this. Where is the order? Huh?
If logic is convinced about the violation, then that's not
No, it is not about me being convinced. It is about you convincing me otherwise. This suffices. Tell us in a sentence, this suffices. Because had it been a view taken, if there was some record saying if it was recorded in this order that yes, this was argued, but we still feel that the case diary should be called for, we would not go beyond it. This is a routine order. Poxco case, so-and-so, issuance of notice, call for the decision. That is how it remained. The violation is there. Statements of all the prosecution witnesses have been recorded.
Yes,
It is now only his defense.
Yes, my lord.
We'll allow it
Yes, ma'am.
based on the violation of the 47 and 48.
Obliged.
So tomorrow when you go there
Yes, at least.
with something happy in
Yes.
hand. Disposed disposed of violation of section 47 and 48 of the BNSS. Notices are not in accordance with the law laid down by the FX code. Article 20, Article 1 violated. Oh, prosecution witness is completed. Defense defense evidence is being laid at the present stage. Yes.
Number of dates for edits.
Ah.
Yes, yes, yes.
We will observe that his absence in the trial, his absence on the dates fixed by the trial court. After this, the trial court would consider the reasons given and may also go for cancellation of the bail.
Madam.
That much has to be there. The trial has to be concluded.
Obliged, madam.
Defense evidence is being laid. In the event the petitioner defaults in appearing before the trial courts on the dates fixed, the trial court would be at liberty to consider the cancellation of the bail if it is of the opinion that there is an attempt to delay the trial proceedings. After everything is done, Mr. Swense appears as the amicus. For the amicus, Mr. Swense appears as the yes.
Your Lordship, but in this matter, my learned friend, then the charge sheet has been filed. My submission, one submission, my lord. My lord, admittedly, when the affair without all these fakes, nothing has been recovered from my possession. My lord, that from the vehicle they have recovered, it is not. I am the owner of the vehicle. I am behind the bar for the last 136 days. So may I pray, my lord, some certain observation made, my lord, so that I could approach before the learned trial court to get.
Heard Mr. P.K. Learned Counsel appearing for the petitioner, also heard Mr. B. Sharma Learned APP, who has submitted that the charge sheet in the present matter has been submitted accordingly. Mr. Deka, by charge sheet number so and so dated
126/25, dated 25/10/25.
Mr. Deka, the counsel for the petitioner has submitted that the petitioner would, this bill petition may be closed by affording the petitioner the liberty to approach the trial court to pray for regular bail in the circumstances. Full stop. Mr. Deka has submitted that there has been no recovery made from the petitioner.
My lord.
No
Yes,
recovery
no,
made
yes,
from the
yes,
petitioner, and
operation.
he is what? Owner or driver?
I'm not the owner of that vehicle.
You are what?
Nothing, my lord. I'm no way connected with that vehicle, my
Ah.
lord. That is yes.
That the petitioner is not in any manner connected with the vehicle. Full stop. The petitioner would be at liberty to raise all such grounds as may be
And learned trial
available
court
to
may-
him
Yeah.
while approaching the
Learned
learned
trial
trial
court
court
may
for
be
regular bail.
directed-
Huh?
Learned trial court may be directed to consider all this.
And learned trial court would consider all
Yes.
grounds raised by the petitioner
Deeply obliged, my lord.
as per law.
Yes, my lord, yes, obliged.
We were under the impression that trial court would not go beyond the law.
Yes.
Yes.
May I please, your lord?
Huh?
Up-to-date CD is called for, however, not received.
Huh? What was the allegation, NDPS? But then, Mr. Sharma, from 27/11,
Yes. No, see, it was received, it was sent back for this.
Up-to-date.
Mr. Sorensen, counsel for the petitioner, the learned APP has submitted that although the CD was received earlier, the updated CD is yet to be received. List the matter again on
Give a short date, my lord.
Fourth of February. Huh? 4th of February. For updated CD.
Obliged.
কোন আপনি আহিবচোন না কোচ লিষ্ট
মানে telephone system, my lord, principal not the same.
60 days, 61.
default.
That's it.
Ha. So default.
Period of detention.
Administrator Sorensen and counsel paying for the petitioner. Also heard the learned special PP appearing in the matter. The petitioner had been arrested on
22/11/2020.
22/11/2025 in connection with offense number ER. You take it from page 1, huh? Not pencil issue. The petitioner was therefore forwarded by the forwarding report forwarded and produced before the learned magistrate on where is it? Huh? Page 8. On 23/11/2025 and has been in custody ever since. The learned counsel for the petitioner has submitted that the statutory period of 60 days for submission of the offense report has been expires today. Expires today, and on instructions received, the learned special PP has submitted that the offense, Special PP Wildlife has submitted that the offense report has not been submitted till now. In view of the above, the petitioner is directed to be released on bail on furnishing a bond of rupees. What did he do? What was recovered from him?
SDJM, Gopur. Within M, Gopur.
No, I'm asking what did he do? Tiger. Furnishing a bond of rupees 30,000 with 2 sureties of the like amount, subject to the satisfaction of the learned SDJM. SDJM? Gopur.
Gopur.
Gopur Vishwanath. The bail of the petitioner shall be subject to such conditions as may be imposed by the learned SDGM at his discretion, and also subject to the following conditions. 1, 2, 3, 4 more quoting episode. Bail application disposed of.
Item 12.
আছে অকমান কৰিব দিয়ক ঘুগুফিয়া লাগিছে কিবা
Yes, please, your lordship. But it my learned friend take time to take instruction whether charge sheet is submitted or not.
Early also.
No,
There were two petitions in two different cases. In the other case, he had moved a AB. Here also, he has moved an AB. In the other case, the charge sheet has been submitted. He has not been put up for trial.
Okay, this case.
So that goes. Now here in this petition, he is praying for grant of PLSP. Huh.
One person has already been arrested.
Huh.
And he absconded from his place of occurrence.
Huh.
So at least he will be able to.
From that place of occurrence, he absconded, but when he was nothing was recovered from his house. Still, we had called for the CD.
The NDPS case also, there has to be something more to be there.
When can you have it?
My lord, from my house, nothing recovered.
Huh?
From my house, nothing recovered.
No, we just want to have a
And-
look at the CD to find out once you jump the wall and run away, how many more times you have jumped the wall?
Yes, my lord, the interim may be given, my lord. I will appear before the police. I may be protected on interim bail, my lord.
No, we'll have it on a very short time. He's saying,
Ultimately, one date already gone.
huh?
It was 1912 was the first date. And my
Yes.
lord, in another case reference given in the FIR, Nazira PS case number 33, I am also involved. That one already honorable court said that.
That is the whole trouble. It was, if this was the only case,
Yes.
we would have been so.
So, my lord, I may pray for interim, my lord, because very unfortunate case, my lord. The person arrested from another house, my lord, and whatever the intermediate quantity
30,
was recovered from his possession.
either 30 or 2nd of February. 2nd of February. Let the CD come.
In the meantime,
Yeah,
maybe
he's a person
protected.
who gets involved everywhere.
My lord, FIR, nothing my involvement. Very clear, FIR is very.
Several FIRs.
No, my lord, already I have submitted against that FIR. I have already done, because I am not involved in this case. Charge sheet could not file. So it means what? Here also same thing will come, my lord.
It has.
My lord, in earlier case also police was searching me. Very important. Police was searching me, but could not.
We
find
will
the
have
charge
it
sheet
on
against me.
we will have it on the 30th along with the case diary, and we will consider it on that day. Heard Mr. Swansea, learned counsel appearing for the petitioner, also heard the learned APP. The case diary called for by the order dated 19/12/2025 has not yet been received by the learned APP. The learned counsel for the petitioner has submitted that nothing has been recovered
Yes, ma'am.
from his residence.
Yes.
And although he was also named as an accused in other cases.
Yes, ma'am.
While submitting the charge sheet, he was not sent up for trial.
Yes, ma'am.
He therefore prays for an interim relief in this case also. Having regard to the submissions made by the APP, lists this matter again on the 30th of January 2026. by which date the learned APP shall ensure the requisitioning of the
I'm
CD.
And 16.
May I please lodge?
Yes, sir.
Not the FIR, my lord, page, my lord, 13, my lord.
Hmm.
In 2021, 2022, my lord, and 22 and 2023 years. My lord, minority scholarship scheme, my lord, was going on. The petitioner is the principal of school, my lord. From his school, my lord, in 2022, my lord, 19 students applied, my lord.
19 students?
19 students applied for scholarship. And in 2025, my lord, one letter from my lord central government was sent to the Assam government, my lord, suspecting, my lord, 71 numbers of the school, my lord.
Ha.
And it was sent for verification.
Which included your school?
No, my lord. Then, my lord, verification was done. Out of 71, 46 is found to be suspected. Then, my lord, police registered a case. This FIR was filed. And notice was issued, my lord, to me, page 20, my lord.
Yes.
Then I appeared, my lord.
Okay.
I appeared, my statement also recorded. The police is, my lord, again, my lord, make me, my lord, call, my lord, for appearing, my lord, after 2-3 days APT, my lord. So I am apprehending that, my lord.
What happened on 26/12/2025?
Lord, I appeared before the police, my lord. 3/1/2026, my lord.
3/1/26. What happened on that day?
My statement recorded. I have produced my all documents, my lord. Then I was allowed to go. So I will cooperate, my lord.
Why do you apprehend arrest?
Because, my lord, now, my lord, police is, my lord, after 2-3 days, my lord, call me in mobile phone to appear, my lord, without issuing further notice, my lord. So I am apprehending.
Scholarship for class 9 and 10. Now, here also what is it, 7 scholars they applied for pre-matric scholarship. But also when an interview was done, it was found that all of the schools, not all of the schools, some of the schools, they do not have class 9 and 10. And
What about your school?
No, I have everything okay, my lord.
Okay, 9 and 10.
No scholarship has
No,
been.
we are just corroborating the fact which should be remembered.
School from the application against everyone was in it, but here it is not in it. From the other case, it was in it. It was part of the application. Now, let's look at it one more thing. Some of the schools, the principal was not there. Some other person impersonated as principal. Their mobile number was given because the beneficiary is to process their phone number. Phone number was even manipulated. Even the Aadhaar cards were manipulated. So those will, if fixed date, will produce the case study.
I am genuine principal.
This is what we do. He says that this is not the complete FIR.
This certified copy, my lord.
No, we do not know.
This much has been furnished to us, my lord.
That is what we don't do. You also try to find out if there is anything left in the FIR which has not come on record.
From page from 10 to 16. Seizure list also given, my lord. We have annexed, my lord.
Seizure list for your school?
No. Our school is not mentioned in this seizure list.
So that is what we are saying. Something must be there against your school. Some paper must be there against your school because you were called. Try and find out. In the meantime, you let us know whether after this 312026, you still need to intend to. That is what you have your information. We'll take it up on the second, huh?
I have already appeared, so my lord, your lordship's query.
Let the case diagram. See, when the school, when a school is involved in taking up scholarships meant for someone else, a little question. We are not disbelieving you. We just want to know what has happened on 312026 and whether the entire FIR is before us or not. Only that much. Copies of the letters are annexed as Annexure 1.
the physical inspection of the suspected number of food issued by segregated testing by the annexure 2. Next paragraph also will see last few lines. The details are yet to be received from students to follow for some investment. And then all those details were annexed with the FI itself. So also will fix it. The case
Heard Mr. Ali Learned Counsel appearing for the petitioner, also heard the Learned APP. Call for the case diary. List again on the 2nd of February 2026. Mr. Ali would be at liberty to file additional affidavit to bring on record any further documents required in the matter. We are not saying what, we are giving you the liberty. If you can find out that there is an FIR which contains all these annexures, please give it to us. Mr. Ali has also submitted that the petitioner has appeared on 3/1/2026 as required by the notice of the investigating officer, and further custodial interrogation may not be necessary. 3. No, not 3. 2. 2nd of February. Right.
May it please your lordship. My lord, this is a Poxco matter, my lord, but Poxco is not against me, my lord. Not against me, my lord. Today morning, my lord, we have filed an additional affidavit. It is also annexed, my lord. My lord, and the informant, my lord, he was a police officer at that time, my lord, at the King police station, my lord. Now, my lord, he is not traceable, my lord, and from I have annexed the orders also, my lord, in the trial court also, he has 6 days has elapsed, my lord, he has not appeared, my lord. So, my lord,
who has not appeared?
The informant, he was a police officer at that time, a Jing officer in charge of the Jing police station.
The informant is not appearing, but what about the victim?
It is 19/126 indicates
But service upon the informant, manner. Informant is a police officer. Lord, in the manner, for manner, service is awaited, manner. But manner, I would like to take my lord, manner. Today we have filed an annexure, my lord.
You have filed an affidavit. Yes,
Affidavit, my lord. Lordship, may I take to at page 68, my lord. Page 68 of the affidavit, my lord. Page 68, my lord. I am Atabor, my lord. Actually, my lord, the allegation of Poxco, my lord, against Tafazul, he is, my lord, already, my lord, in the other world, my lord. And other 2 persons where he had accepted my help in Faridul and Golab, my lord. They have been granted bail, my lord. And I, my lord, is the Atabur, my lord. And the allegation
Faridul has been granted bail.
Yes, my lord. Faridul and Golab, they have been granted bail. Put order. Yes. And an allegation of Poxco not against the present petitioner, my lord.
Well, what was your role in the
Page
affair?
41. I'm page 41, my lord.
What was your role in the matter?
Page 41, my lord. Page 41. Page 41, my lord. 11. Serial number 11, my lord. Serial number 11. Are it bail that is put together? Order 800 of 4 59. 48.
You are the brother-in-law.
My lord, brother-in-law, allegation is that he helped in dismantling a motorcycle, my lord. That is the allegation. And my lord,
2 named accused have been granted bail.
And 42, paragraph page 48, my lord. The other 2 persons who helped Tafazul, my lord, in commission of the alleged crime, they were granted bail, my lord.
That is because grounds of arrest were not communicated.
Yes, my lord. That is true, my lord. But they have been granted bail. And my lord, even the victim, my lord, she has clearly deposed, my lord, that she does not. She has no. She does not know me, my lord. From her deposition itself, my lord. And more than 6 months in jail, my lord. 185 days in custody. And Poxco not against me, my lord.
Your name is Atabur.
Atabur, my lord.
Why 6 and 17? Come 6 and 17. What a second. Abetment. Mr. Sharma, page 63, Atabur is being, it was presumed that Atabur has committed offense under section 17 of the Poxco Act. 17 is abetment.
Yes.
But whatever Atabur has done, apparently has been done to hide that bike,
Yes.
not in the abetment of the offense.
Yes, that is correct.
That part is there. One. Two, the two persons who had actually committed the act are on bail.
One guy.
One of them is on bail. He only dismantled the motorcycle. Evidence of the prosecutors was already on, what do you say? I have said these things only to say that why I am inclined. Disincline me, I am ready.
There is an independent witness.
Hmm.
Lordship can ensure that they are not tempered with lordship. Then they
Those things will be there. They will not be anywhere near any of the witnesses, the victims. They will not leave everything will be there, but his custody, further custody,
that is lordship PW 17. That is
he has only, if at all, he has helped destroy the evidence, that bike.
Yes.
No further. Okay. Heard Mr. So-and-so and counsel appearing for the petitioner, also heard Mr. B. Sharma. The petitioner had been arrested in connection with Special Poxco case number 179 of 2024, pending in the court of the learned Special Judge Poxco, Nagaon, Assam. Full stop. Petitioner was taken into custody on 21/7/2025. The allegations are under section. You take it from page 2, huh? Take it from page 2. Under section so and so. Learned counsel for the petitioner has submitted that the petitioner is the brother-in-law of one of the accused. And where did you show us that page?
Page 41, paragraph 11.
Brother of one of the accused who was alleged to have committed the offense. And as for what is this? As per the charge sheet, this is the charge sheet. Part of the charge sheet you have
Part of the
clearly-
charge, part of the charge.
As per the charge sheet, the allegation against the present petitioner is that he had that the bike used by the accused was found in a dismantled condition from his possession. Full stop. The learned counsel submits that the allegations under the Poxco Act are not applicable to him, and therefore are not applicable to him. And further, the prime accused has been granted bail. One of the prime accused has been
Two
granted.
of the prime minister has been granted bail, one my lord has.
Two of the prime accused have been granted bail and one has met his demise. Full stop. In the circumstances, keeping in view the fact that the statements, the evidence of the victim and a victim has already been recorded. Full stop. He has prayed for being granted the privilege of bail. The learned APP has submitted that and has opposed the prayer for bail, saying that the matter is of a serious nature and granting bail at this point of time may hamper or temper the may enable the petitioner to hamper and temper the further evidence which is required to be recorded in the matters. Full stop. The trial court records received have been produced. In these circumstances, this court is of the opinion that the petitioner can be granted the privilege of bail. Make it 30,000, two sureties of the like amount, subject to the satisfaction of the special judge Poxco, subject to the following conditions. The learned special judge shall also be at liberty to impose such other conditions to ensure the participation of the petitioner in the trial proceedings.
I'm obliged, my lord.
Condition বিলাক পিছত দি দিম বা বেলেগত আছে নহয় তাৰপৰা উঠাই দিম হা yes
May I
please
please, Your
post.
Lordship? Lordship, this is a charge sheeted matter, Lordship.
PCR has it been received?
PCR receipt.
Huh?
Commercial quantity, Lordship. So,
When were you arrested?
Lordship, 7/5/2025, Lordship. As on today, Lordship, 259 days. 259 days, Lordship.
Lordship submitted on 19/8/25, and section 22C. Charge framed on 6/26. Very easy to the file. With no PW examine. 7 PWs are there.
Lordship, in this petition, Lordship, I am on 2 grounds, Lordship. Violation of fundamental right, Lordship. Lordship, one is section 48, Lordship, notice. And another one is, Lordship, arrest memo, Lordship.
Harassment?
Yes, Lordship. Section 36 of BNSS, Lordship. As per section 36 of BNSS, Lordship, the investigating agency, Lordship, investigating officer, Lordship, at the time of making the arrest, Lordship, they prepare a memorandum, they shall prepare a memorandum of arrest, Lordship, and the memorandum of arrest should be attested by at least one witness, Lordship. And thereafter, Lordship, the same is to be countersigned by the arrestee, Lordship, accused. So in this case, Lordship, page 31, Lordship, the arrest memo, Lordship. There is no signature of the witness, Lordship.
Just a minute.
There is no signature of the witness, Lordship.
Where is it?
Page 31, Lordship.
Signature and name of relative or witness.
Yes,
That one?
Lordship. Relative or witness, Lordship.
From where do you belong to? West Bengal.
Coach Bihar, Lordship.
Coach Bihar,
Yes,
West
Lordship.
Bengal.
Lordship.
You are arrested in the Guwahati
Lordship.
railway station.
Lordship.
So they should have gone to West Bengal to bring your.
No, Lordship. It is the mandate of section 36 says that, Lordship, the signature should be taken from first
Independent.
given to relative or family member and any local.
In the railway station, you did not find a GRP or somebody. People were there. No signatures. Page 31.
Any respected person of the locality, Lordship.
GRP would be there. TT would be there. And what about?
48.
Huh?
48 years.
48 notice was served on?
On it is shown as some Arup Goswami. We don't know him, Lordship.
Signature of informed person.
Yes, Lordship.
Oh, please see who is the person being informed at the top.
Lordship, I want to submit, Lordship.
At the top, who is the person being informed?
Chairperson of Nagaric Committee of Panbazar PFs.
She must not be deaf. She must not be a dumb person. Some name must have been given. Yes, whose name did you give? While being arrested, whom did you want to be informed?
Lordship, any
Who was
relative-
supposed to be informed?
Lordship, family.
Oh,
Lordship.
if you are going for 48.
Lordship, I want to submit bail order, Lordship, of coordinate bench, Lordship.
Please.
Where the accused in case of associated commercial quantity case, Lordship, been granted bail only on sole ground of section 30, violation of section 36, holding that section 36, Lordship, is a provision which flows from, Lordship, the article 21 and 22 clause 1 of.
Show us. Yeah.
In this case, Lordship, Lordship, we are relying on judgment of Honorable Supreme Court passed in GK Basu case, Lordship. I have submitted 2 different bail orders, Lordship. DA number 2.
Yes. 36. Railway station, that is what we are trying to see, 3:45 AM in the morning. If on a lonely road, situation would be different.
Yes, section
Railway
62 also,
station,
Lordship.
violation 36.
And section 62 also, Lordship, of BNSS, which states that no arrest shall be made except of this Sanhita, Lordship. The arrest should be made strictly as per this Sanhita, Lordship.
48, in the absence of his statement that he had nominated some
Yes,
person to be
person.
informed, we are not going into 48. But 36, what do you do? Allowed? Yes. Tomorrow. Tomorrow is 22nd. Only to that extent. Only 36. Tomorrow. At the request of the learned APP, list the matter again tomorrow.
Obliged, my lord.
Tomorrow date to file did you? 22.
Please, your lordship, my lord.
Yes.
My lord, in this case is though registered under Poxco, my lord, but it's actually the matter of child marriage, my lord. My lord, if your lordship can go to the FIR is at there, my lord. FIR is at page number 10. Okay, my lord, the girl and the boy eloped, she became pregnant, and the husband took her to the medical checkup, regular medical checkup. Then doctor informed the NGO. NGO in return informed the Panchayat secretary. The FIR was lodged by the Panchayat secretary, my lord. And the baby was born, my lord. And the father is still in behind the bars, my lord.
What about the? Yes. You want him home? Huh? So you want him home? Huh?
Because they have the mother and child protection card also. From page number 23, my lord, in the chart sheet, my lord. Page number 23 in the bottom line, my lord. So it is a during investigation, victims Aadhaar card, mother and child's protection card, and birth certificate, and other relevant documents were seized. That means, my lord, they are not like that. They are just husband and wife. They go on to a regular checkup to the local PSC, and the local PSC, due to section 21 of Poxco, they inform the police.
Arrested when?
Arrested 21/7/2025, my lord.
Heard Mr. Swain, learned counsel appearing for the petition. Also heard Mr. B. Sharma, learned counsel, learned APP, and appearing for the respondent number 2.
Yes, sir.
The petitioner had been arrested in connection with session special case number 202 of 2025 under section 65(1) of the BNS read with section 6721 of the Poxco Act, which is pending in the court of the learned additional session judge cum special judge Poxco, Kamrup Metro. The learned counsel for the petitioner has submitted that the petitioner had been arrested on 21/7/2025 on the basis of an FIR lodged by the secretary of the Gaon Panchayat, who had informed the police that the medical officer had informed him that a girl of 16 years was pregnant. Full stop. On taking up the investigation, the petitioner, who was having a marital relationship with the alleged victim, was taken into custody, full stop. Mr. A. Kanikar, learned counsel representing the respondent number 2 has submitted that the petitioner is the husband of the alleged victim, and a girl child was also born on
Male child, my lord.
a male child was also born on
25/8/2025.
25/8
2020.
2025, full stop. He has submitted that he is under instructions that the alleged victim is under no threat from the petitioner, since they are husband and wife, full stop. He has further submitted that he is under instructions that the release of the petitioner on bail at this stage will not hamper or temper the investigation or dissuade the alleged victim from making true statements during the investigation, full stop. We have gone through the contents made available to us. We have also considered the circumstances. We deem it fit that the petitioner be granted the privilege of bail at this stage on furnishing a bond of ₹30,000 with 2 sureties of the like amount, subject to the following conditions. Bail application disposed of.
Obliged, my lord.
36.
Oh, the disposal of this bail application will not influence the investigation or trial in any manner. Yes, sir.
May I please? This is a case registered under section 6 of the Poxco Act. That it was arrested 14/10/2025. Apply your lordship will find it was caused by one on the murder of the girl, victim girl, my lord. That is on lecture 1, page 8, my lord. He was missing, my lord, from the home, my lord. Whereabouts were not known, my lord. And on basis of this FIR.
Where is the FIR?
Page 8, my lord.
8.
My daughter so is it about so and so? He was missing from his home today on 24/8/2025. She was missing from 23/8/2025 on 24. Unknown call number being so and so called up. Not that informed that his daughter is in Burma. Wherever asking to come. But when they found that the location was wrong. So then thereafter, on the basis of this information, a GD entry was made, my lord, and the police made an inquiry, my lord, that your lordship pays found it pays 13, my lord, and lecture 2, my lord.
Annexure 2, page 13, yes.
I have report upon the receipt of complaint. I have recorded a statement, complaint and witness. Further, during the inquiry, victim girl was recovered, and during the recording of statement.
Yes, sir, we have read it.
Yes, yes. On basis of this, the case has been registered under so and so. Now, actually what happened, my lord, this accused had an affair with that girl, my lord. She's around 16 to 17 years. And it was a purely love affair, my lord. Nothing more than that, my lord. And it was a consensual one and additional love, my lord. And only recently, Supreme Court also, a number of cases has that in case of already recommendation has made by the.
And I filed my one affidavit, my lord. Yes, I do not have any objection if it is allowed to convey because not I corrected. Subsequently, I came to know that my daughter, I am the mother of the victim girl, and she told me that she had a love affair with my lord.
The statement appears that this during the investigation, the minor victim has been making a very different statement. She must have been examined. Where? No, there must have been a statement before the.
Statement.
Where is it?
I have like my report. In the DCR portal.
DCR function. I have like DCR, please.
The petitioner forcefully sexually introduced twice.
Age of the victim? 14.
Date of birth is the
16.
16/4/2010. So 14 plus.
2010, the 15 plus. Around 16 years. I'm living in a house by the-
And she got some injury in private park also. My her statement.
Why is the mother agreeing? Why is the mother agreeing after this kind of a statement by the minor?
Like, for my instruction, he eloped with the accused person.
No.
And because he was missing for.
This is becoming dangerous. The girl makes another statement before the magistrate.
My lord. Intervention of. This and all, my lord.
This is the exact influence that we don't want to have in a Poxco matter.
My lord.
This is the exact influence we don't want to have in a Poxco matter. The minor should be at the liberty to make her own statements.
Both the
Adults coming to a,
age difference is not there. The accused is also young. and
could be,
is
but the
also
statement,
young.
have you seen the statement made by the minor?
No.
It is,
By the victim, that I have filed this.
no, not the victim. You are appearing for the mother of the victim.
Mother.
Mother of the victim. That is what we are saying. Two adults are now consenting
My lord.
to something that the minor is saying is not correct. The minor says that I had ordered something in Misho, some app. He came as a delivery boy. He got the phone number. Some talking started. He threatened the family that I will have your family picked up. She went to meet him out of fear. Then he took her to some place, tried to give a scooter on this thing. জবৰদস্তি মোক তাৰপিছত সি মোক খানাপাৰাত লৈ গৈছিল এখন স্কুটি বন্ধকত দিবলে, বন্ধকত দিব নোৱাৰি মোক মোৰ ফ্ৰেণ্ডৰ ঘৰত নমাই দিলে. All this cannot be made up.
That is why I filed this case. How is it?
No, the statement is totally different.
How is this situation when my lord? Because
Mr. Kotoki, if we allow this person to be out, he will do further influence on the minor.
I understand, madam. Now, the question is that now trial.
Because now we are, now the mother is being represented.
No, I understand,
The
madam.
victim
What is the-
statement is totally different.
I understand, madam.
This is
Now,
what we fear.
most of the case has been succeeded. Succeeded case, madam. So if it is succeeded case.
Charge sheet on 2018-25. There are 8 PWs and charge not framed yet. Charge date was 6/1/28 for production. Charge is not framed yet. May I submit one thing? I think my lord, because I'm representing the mother, madam. Because I'm not aware of these statements that have been made before.
We'll keep this pending, have your instructions. You may have your instructions, but at this point of time, this court is feeling that two adults are now trying to convince a minor. I am not happy about that. I won't go to that extent. I will go by what a minor has stated before a judicial officer.
That will cause prejudice to trial court, madam. If your statement is recorded here, they will cause prejudice.
No, the mother, what
Yes,
the mother may like to have to say to us is what he's suggesting. We are not interested in that. When can we have it, Mr. Kotogi? We are not convinced.
I understand.
This is influence.
I'll take part.
When?
Any day, my lord, next week.
Not next week. We'll have it on either the 4th or the 2nd. It will refresh korok di. Bhul ke mari team. 4th or 2nd, tell us. 4th. The scan copy of the trial report record has been received. On going through the same. And the same has been produced. The learned counsel appearing for the respondent number 2 has sought for some time to have instructions from the respondent number 2. Accordingly, list this matter again on the 4th of February 2026.
My lord, this is Poxco case, lordship, section 10 is there. And succeeded case, TCR has already been received. Only the notice, lordship, on the last occasion also, my friend was directed to obtain instruction whether notice is served or not.
Yes.
Already 64 days.
Try to get the instruction, but instruction will start from the beginning.
But only telephonic instruction is enough in this case. On the last day also, they took time to that effect. 64 days behind the bar, trial comments already, section 10 is there.
He is a teacher.
My lord.
He is a teacher.
A teacher, but lordship, he is a victim of circumstances, lordship. No such event was a lordship happened. In fact, lordship, he became the victim because all the times, lordship, all the students were they are teachers were there. He was along with the teacher. Now 64 days, lordship, considering that aspect, because section 10 is there.
During a school trip. When was the school trip? 16/11.
19.
So 16 was the school trip, 18 is the FIR. This is what were you saying?
Adults also.
Adults also.
But considering the length of detention at this stage, because
From?
my lord, 64 days, lordship. No, it is not a case of section 4 or 6. This is section 10. Maximum sentence is 7 years.
The legislature may think that it is, we can bring it down. Child is a child.
64 days, maximum is 7 years.
Yes, on an understanding that if on the next day the service report is not there.
On 27, lordship, can be, because only telephonic instruction information is required, whether sharp or not.
27.
Lordship.
By which date the APP shall have the
Positively, lordship.
positive report as to whether the respondent number 2 has been served. We'll consider that there is. Service report, how can we consider? Without service report, how can we consider without the victim being represented?
Please, my lordship. This is the succeeded case, my lordship. Petitioner has already been behind the bar for 231 days. This is the NDPS case, my lordship. And the allegation is that the accused person was arrested in the railway station, Rangapara railway station. And but the so far, the seizure list is concerned, and the seizure list indicate that the name of the accused person has not been mentioned in the seizure list, my lordship. This is the para number 19. May I have 20?
Page 19?
Yes.
Is
Is the
SIRPF Sohanlal
Yes.
Pradhan, who is he?
He is a complainant, informant.
And the material has been seized from him.
Yes.
No, that was find out they are boarding on the train and the suspected contact was recovered. See, the huge crowd was there. That's why he has reached the contraband to a station. Thereafter, it was seized.
But my lordship, to establish the conscious possession, The possession should be shown.
No, it was inside a train,
Inside the place.
inside a running train.
Inside the place.
The person was not apprehended on the spot.
After the apprehended, they have admitted the facts, Lordship. Yes, they are bags.
Mm.
But without the authority letter, the authority was sent them to search the bags. After receiving the authority, they are searched, but in the meantime, crowd was there, so they will wait for the station, Lordship. Just taken back down to the station and up they are perceived by the informant.
But the law is said that to establish the conscious possession, there should be that
Case of
contraband
trial,
should be recovered from the.
That is your argument in trial.
And
Yes, sir, but just
Tell us about the bail part, huh?
Here, the two person was arrested. There is nothing mentioned what quantity of ganja has been recovered from the each individual's accused person. And also in the seizure is also there is no signature of the accused person also. And all the witness also, all the official witness. There is no any independent witness in the seizure list, my lordship.
All this in trial. Tell us about the bail.
But so far, if the law is concerned, my lordship, my humble submission that the accused person has already been behind the work for 231 days.
For 31 days?
Yes, 231 days.
231 days.
Yes, sir. And here the ground is that the seizure list to establish the conscious position.
What is the quantity recovered?
21 kg.
21 to 700.
700 commercial quantity, my lordship. But my humble submission is I argue on the basis of the seizure list to establish conscious position. If there is no any proof to establish
The seizure witness statements are there, they have only established the materials recovered from the possession of the petitioner possession.
checking all these aspects, my lordship.
First framed on 15/9/2025. So at least last it was 51/24 April. 51 has already gone, whether it is if further improvement is
Yes,
there.
so far my knowledge is concerned, witness has already been done.
2 witnesses?
Yes.
Who are they?
It is.
Huh? 6 PWs, 2 done.
Yes.
Let 2 more come.
But maybe it.
And in the record, it was, last it was 51/26 for evidence. So 2 witnesses.
After that, 2 witnesses have gone. We'll call for the updated CD. We'll wait till 2nd of February. Let us see. Huh? The Learned Counsel for the petitioner submitted that 2 witnesses have till now been examined by the prosecution. Full stop. Call for the updated proceedings. Call for the scan copy of the updated proceedings.
So next date is
21 February.
21?
21 February.
Next date.
21/2.
21/2.
Day after, if any.
Call for the updated status, updated proceedings of the trial court. List again on 25th of February.
Yes. Yes.
25 February, huh?
Masuk.
May it please, my lord. My lord, commercial quantity NDPS matter, my lord. My lord, a similarly situated person has been granted the privilege of bail by the honorable court below, my lord.
In the same case?
Same case.
Same FIR?
Same FIR.
Sure.
My lord, through a supplementary charge sheet, he was implicated in the case and he has been granted bail. If my lord would kindly have, my lord, page, my lord, 53, my lord, 53. My lord, the said person, my lord, Mr. Noren Borua, he was implicated, my lord, through this supplementary charge sheet. And if my lord has the next page, my lord, at page, my lord, 55, my lord. 55, my lord. The earlier page is the type process, this is my lord. CR is put up today on the strength by the petitioner for submitting bail bond for accused Noren Borua as per order dated so and so. Prayer is allowed. So, my lord, this is a subsequent development in the case.
Where is the bail order?
My lord, he has been granted the bail, my lord. This is the order, my lord. Page 55, my lord.
This is the bail, this is accepting the bail. On what ground was he granted bail?
My lord, grounds are not elaborated, my lord.
So, it is also, please wait.
Order dated 9/9/25, passed by the honorable court.
Recovery was from these petitioners.
Whose?
this petition.
No, my lord, there is a catch to that also. I'll enlighten upon that as well.
Yes, what is the catch?
My lord, on 17/6, my lord, if my lord has the forwarding report at page 42, my lord, of the petition. Incident had occurred on, my lord, 17/6/2025, my lord. There was a collision between our scooter and a e-rickshaw, my lord. Thereafter, my lord, one of the applicants, my lord, he was injured and he was taken to the nearby hospital. And my lord, the other applicant was also taken along with him. And eventually both had, my lord, they were in the hospital. Now, my lord, as per the search and seizure list, my lord, at page 24, my lord. Of the petition, my lord, what have. Here also, my lord, it is written that date and time of seizure 17/6/25 at about 3:30 p.m. Whereas, my lord, the incident had occurred at 2 p.m., my lord, in the afternoon. I was injured. I was taken there, my lord, to the hospital. Then, my lord, would kindly have page 25, my lord. Next page. Below portion, my lord, signature of both the applicants are there. So, my lord, it is not possible that within a span of 1.5 hours, we had come back and there the search and the seizure was done, where the material was recovered in front of us, my lord. It was done behind our backs in the presence of witnesses. That I am not disputing, my lord. At page, my lord, 25 only, there are signature of witnesses. That is true, my lord. But, my lord, there was an accident, my lord. I was taken to the hospital at 2 p.m. Then again, 1.5 hours medical was done.
From where do we find something to show that you were taken to the hospital at
My lord
2
would
p.m.?
have the forwarding at page 42, my lord. May I read, my lord?
One of you were there.
No, signature of both is there, my lord. One was doing medical, my lord. Not possible, my lord. It is there, my lord. May I read the second paragraph, my lord, if it pleases, my lord? Page 42. Upon arrival at the PO, it was found that one of the injured persons had already been shifted to the Koliabor subdivisional.
Yes. How can both sign it?
That is the thing, my lord.
How could both the persons sign the seizure list?
Moreover, my lord.
Some manipulation.
My lord, section 48 and 47 notices were submitted on 18/6. Again, my lord, that judgment of the Honorable Apex Court, my lord, would come into play, my lord. Mihir Rajesh Shah, my lord. That has to be complied with, my lord.
Which one?
Mihir Rajesh Shah, if I may kindly hand over, my lord.
Tell us what has not been complied with.
My lord, handing over of the arrest memo, my lord. Here, my lord, it was laid down. We thus hold that in cases where the police are already in possession of documentary material furnishing a cogent basis for the arrest.
Oh no, your first question is answered. The injured individual, after receiving preliminary medical treatment, was brought to the place of occurrence for necessary follow-up action.
My lord, but 2 p.m. the incident occurred. In 2 p.m. the incident 3:30. How can it be so fast, man? There is a collision with. There was an accident, my lord, proper accident.
But preliminary treatment was done there.
Okay, then.
And thereafter, my lord, as per the mandates of section 50 of the NDPS Act, my lord, the search has to be done in search in compliance with section 42 of the Act has to be done in the presence of a magistrate, my lord, or an authorized officer. That has also not been done. Nowhere it is reflected, my lord. If my lord would kindly have the NDPS Act for a moment, if I may read, my lord.
Let us not disbelieve. Let us not disbelieve this This search was carried out in accordance with the provisions of section 50 and other applicable sections of the NDPS. Search was conducted in the presence of the following after obtaining proper authorization from the CDSP Koliabad, thorough search of the vehicle was conducted. Then you were saying something about Mihisa.
Yes, my lord. Mihisha, my lord, has clearly erred regarding that, my lord.
Which?
My lord, before being produced, my lord, before the
2 hours before being.
2 hours, 2 hours, my lord, that 2 hours, that was not given because, my lord,
Why?
on 18/6 we were given the 47 and 48. On that day only we were produced. My lord, sufficient time was not given to us.
2 hours.
2 hours. Incident occurred on 17/6. My lord may kindly appreciate. 17/6. I was with them, my lord. All throughout I was with them. We were with them. They could have given us the at least the 47 notice. 48 notice, I understand. That has to be given to a relative.
17/6 you were arrested.
I was in there.
You were taken into custody. We'll take it to be in some of the cases we have seen or we have also held.
Yes, my lord. Now, my lord.
Once you are taken in.
Yes.
Thereafter you are arrested, you are in custody all along. So
Yes.
the 24 hours starts running.
Yes,
Okay.
my lord. 2 p.m.
Now,
my lord would appreciate. Since 2 p.m. I was with them.
On 17/6.
17/6.
Very well.
Thereafter, my lord, all throughout they didn't give me the 47 notice. They could have given, that is to be given to me. 48 notice, I understand. That has to be given to a friend or relative. Next day it was given to my relative. 48 notice. That is not disputed. But 47 notice, they should have given it to me. I should have known about my grounds of arrest. That was not given.
Yes, a new argument. A new argument at the earliest point of time, if not possible, at least 2 hours. At the earliest point of time. Did you give it at the earliest point of time?
They have defeated me. With due respect.
Hmm?
Well, they have defeated. My lord, violation.
How was the earliest possible time to give the
sufficient time was there?
Charge is paid already. Even below there in the time of question prior of
So that should stop us.
Appear in the trial, my lord. Bail may kindly be granted. Since the last 210 days, we are already languishing in jail, my lord. We want to appear for the trial, my lord. Kindly grant us bail, my lord.
That is today, 21/1/26 for evidence. Any further evidence?
We will come, my lord. We will come since they have flouted, my lord. Kindly, my lord.
There are even penalties.
My lord, there has been procedural lapses also. Section 50 has also been flouted, my lord, with due respect. And my lord, there is a authority also, my lord. Arif Khan versus State of Uttar.
Page 31 for a moment.
Yes, ma'am.
Third last line.
Yes. Yes. Yes, my lord.
Read the whole line. Date and time of arrest on
18/6/25. At about not written. By.
That is Kadir. For Zuhir, it is by handwritten.
My lord, at page 33, they have inserted the time, my lord, subsequently.
When?
33. 31, it is not there. Same offense. One time is there, one time is not.
Today was for PW.
Today for PW. My lord, but
both, huh?
First date, my lord. Before that, the trial has not commenced properly. Production stage only, all throughout, before filing of this bail. Today only, as my learned, respected senior friend is saying. Today only PW, perhaps. But before that, the trial was going in a snail's pace, my lord.
Now it is sped up.
No, my lord, would kindly appreciate there has been violation of my Article 22 of the Constitution. My right, my lord.
It does not appear.
I'll appear for the trial, my lord. We'll appear for the trial, my lord.
289 grams. Yes. Hello.
Date and time. If date and time, then we have to confirm that. prejudice factor of the person case. If they are aware of the factor, they can argument on make the choice. Otherwise,
My lord, my lord,
at this stage of bail cannot be granted.
my lord, my
Friday, let him say what he has to say on the darshan. We'll have it on second.
second, my lord, I'm not here, my lord. My lord, can it be tomorrow, my lord?
Tomorrow is a bit difficult, second or fourth.
My lord, I'm not there, my lord. That is why.
Okay.
Tomorrow, my lord, kindly, because my lord, can come small instruction.
Tomorrow 51 cases fixed. I do not know what
My lord, again,
other long list will come.
my lord,
Then we'll listen to you. Then we have a few days vacation.
my lord, please tomorrow, my lord.
27th,
Report will-
Tuesday. Immediately. on
If
Tuesday.
my lord, if it pleases my lord, matter may be kept as part heard. If it
No,
pleases,
it'll come, it'll come.
Again.
Don't worry about that.
same set of arguments.
It'll come back. Don't worry. 27th. Allowing the PP to address this court on the prejudice.
Because
At the request of the learned APP, list this matter again on the 27th.
Part heard, kindly.
The only difficulty is whatever we say today will have consequences.
Yes.
So let him have his say.
Yes, my respected senior,
Let him have his say on 27th. We'll
if it is part heard, my
deal
lord.
with it.
My
Huh?
lord, as part heard, kindly.
No part. It will come.
Okay.
Need not wait.
Deeply.
It is supposed to come.
Oblige.
What do you have?
May I
Yes.
please, Lord? I may be allowed to withdraw this petition at liberty
Lord,
to
it
file a fresh loan.
Why?
Some discrepancies is here, Lordship. Actually,
Huh?
miscommunication is here.
Why? Can you take up this case for a moment?
I am telling you.
Is it something very fatal?
That's why I'm telling you. No. Actually, I want to press.
He would have answered. Let him answer.
Actually, the case is conducting by the learned LEDC council, Lordship.
Huh?
The trial is conducting by learned LADC, Lordship, DLSL, Lordship. The deponent is a literate lady, Lordship. He is not aware about the pendency of the case in the trial court, Lordship. Earlier, it was conducted by the learned defense counsel private counsel. He has filed in bail application, which was disposed of. Later on, subsequently, after some days, another bail application was filed by the learned defense counsel. And it was ordered there after deposition of informant and informant and victim, the bail application will be considered. Thereafter, on 10/10/2025, PW1 and PW2 was
examined.
And on that day, the learned contracting counsel was thought that the bail application was rejected, Lordship. And thereafter, he was left to conduct the trial, Lordship. Thereafter, learned DLSA was appointed, Lordship. And he was not about the pendency of the earlier bail petition, Lordship. And while the deponent asked to the learned DLSA, he was supposed to tell him that no bail application is pending before the learned trial court, Lordship. Thereafter, it was filed, Lordship.
So 15/12 there is an order hearing on the bail petition. You want to pursue that bail petition instead of this bail petition? Look here.
I'll file a
Heard
fresh
it on it.
application after.
Huh?
I will file a fresh application if required, Lordship.
The counsel for the petitioner has submitted that due to a misconception and miscommunication between the petitioner and the counsels appointed, including the counsels appointed by the DLSC, although a petition was pending before the learned trial court, this petition had been filed. He fairly submits that this petition does not need an adjudication at this point of time, and he may be allowed to pursue the bail petition filed before the learned trial court. Although this court does not appreciate the manner in which this bail petition was filed, accepting the statement that it was on the basis of a miscommunication, this bail petition is closed as not pressed, allowing the petitioner to continue to pursue the bail petition filed before the learned trial court without prejudice to the closure of this bail petition.
Obliged. May I please, your lordship. This is regular bail application, lordship. Here in this case, lordship, I am not, I am pressing not on merit, lordship. And 79 days in custody and 90 days is mandatory period, lordship. And only length of detention may be considered, lordship. And FIR will be fined page number 11, lordship.
What is the allegation?
FR page 11, lordship. Only some fake currency and some fake gold, lordship. And there are 3 persons, lordship. But this. Length of detention only when the local person, lordship, enters. Face the trial and if charge sheet submit, lordship. 7 days. 90 days. And he's residing
But it is
within
a
the
fake currency.
lordship.
Fake currency is involved.
But until unless, lordship, the FSL report, lordship, so lordship, I am not, lordship, and only length of detention may be considered, 90 days, lordship, and local person from sanctuary, lordship. And so any condition may be impossible.
Which one? You are for accused number 1.
One, lordship. But that is serially, lordship, and
Huh? It breaks down the entire economy, sir.
length of detention may
It
consider.
hurts the economy.
Local person, lordship,
Huh?
from
11 days more. 11 days more to go.
and lordship, the police and sufficient time got for investigation, lordship, and so charge sheet yet not been
If
filed.
it is a fake currency, I do not know.
So, lordship, and the condition may be imposed, lordship. I am the local person from sanctuary, permanent resident, lordship. Any condition, lordship. Any condition.
What about the other 2? They have also filed.
They have also filed, lordship. Perhaps, lordship, but I have no
They must come up together then, if it is from the same FIR.
79 days, lordship, may consider, lordship.
Fake currency, nothing. Second.
Yes, mandatory period will be over, lordship. Condition may be imposed, lordship, and lordship, and
Fake currency. That is the only golden boat would have been a different
and lordship.
aspect.
But there are 3 persons.
433 numbers of 500 rupee notes. Huh?
3 person, lordship, but
Huh?
but there is no very clear, lordship, and certainly, lordship, mentioned the person.
Either they
from
file
whom
the
this-
either they file a charge sheet or you get the default bill.
And lordship, my one.
Fake currency, we are not
one
doing it.
little submission out of same FIR, lordship, and one BA, lordship, and 118, lordship, supposed to be listed today, but not listed. Connected matter, lordship, may be fixed together.
Huh?
And
List
BA number
these matters
118, 2026.
along with 11, BA number
118,
Ah.
2026.
118 of 2026,
Fixed, no, fixed. Today supposed to be listed, but not listed, lord.
not listed.
So
We will come up together on the second.
lordship. Before 2, lordship, and 90 days will be
Huh?
complete. 90 days will be complete. And 28, lordship, and one chance.
Okay, 28,
Jalukbari.
28,
Deeply obliged.
28.
Deeply obliged. Obliged.
May it please your lordship.
Yes, sir.
438 application, my lord.
Hmm.
I am on interim bail, my lord. 11/9/2025, I was granted interim bail.
Hmm.
Now, here in this case, my lord, what happens? To cut the long story short,
Huh.
these are 3 brothers, my lord. Now, eldest son was arrested. He is a public servant, my lord, arrested for disproportionate case.
Hmm.
The middle brother was arrested for disproportionate case. And thereafter, while investigating that particular case, if your lordships comes to an affidavit, additional affidavit, my lord, I have filed it, it's part of the record.
Hmm.
We'll kindly see the annexure herein. Now, in regarding
one?
the same investigating officer,
I'm sorry, which one? What were you referring to?
additional affidavit, my
Huh?
lord, and the annexure at page 71, my lord, will kindly see. Page 71,
Huh?
that investigating officer is one Boiso, my lord.
Huh?
At page 71
Yes.
is a case number, my lord, with regard to another case with regard to brother, wherein at page 72, my lord, will kindly see page 72, last document that has been seized. one original sale deed executed between Salamuddin Ahmed and so, deed number so covered by Dag number so along with other papers, 7 sheets. Am I clear? Now, on that very basis, my lord, this FIR has been lodged against my client. That comes in page 19, my lord. And here in page 19, my lord, with regard to the allegation at page 20, my lord, will kindly see page 20. Now, there is a EWS quota, so far APSC is concerned, economic weaker section. Now, I have applied for that particular quota because I think that I fall within that particular quota. And I have to apply before the circle officer who grants it. Now, the circle officer by Mondal send in and verification been done, and thereafter on basis of verification, it's been granted to me. I fall under that quota, I've been selected, I've been working. Now, my lord, you can see the allegations, my lord, here. The report from the present circle officer, dispute revenue circle, revealed that the original documents submitted by so, that is the petitioner, for obtaining the EW certificate are missing and could not be located, reportedly due to office record relocation during the construction of so. However, a fresh field verification was conducted, during which the following facts emanated. A. An EWS certificate bearing 475 of 2020 on 27/2/2020 was issued from the Office of Circle Officer, Dispute Revenue Circle in favor of Ijaz Yusuf Ahmed for availing benefit in education and public employment under the government of Assam. This is admission. The certificate, although genuine, the certificate issued is genuine and duly signed by the then Circle Officer Lakshajyoti Das appears to have been issued without adherence to eligibility norms and as prescribed by the prevailing standard operating procedure SOP of EWS certificate. C. Field verification was again conducted on 13/6/2025. This is important. Which it was found that Ijaz Yusuf Ahmed, father Salahuddin Ahmed, is the record owner of a plot of land measuring 4.23 R, equivalent to 1 katha 11.62 lesa. Lesa covered by Dag number, Patan number, situated village so and so as per Zamamandi records. Am I clear?
We can just, I'm just trying to find out another thing.
Yes.
The order dated 11/9 where the interim was granted.
Yes,
You have the
yes, I'm on interim.
Kindly read paragraph 4.
Yes.
Learned counsel for the petitioner has submitted that the alleged EWS certificate was issued by the petitioner or to the petitioner?
No, circle officer issued it. I'm
petitioner.
I'm the beneficiary.
Yeah.
Okay.
Please.
My lord will kindly see, this is very interesting. How, to what extent the investigating officer went to the extent of lodging an affair at page C, my lord, page 20C. Field verification was again conducted on 13/6/2025, during which it was found that Ijaz Ahmed, father, so and so, is the recorded owner of a plot of land measuring 4.23 R, equivalent to 1 katha 11.62 lesas, covered by Dag number so and so, Patan number so and so, situated in village so and so, as per Zamamandi records. My lord will kindly see. The original affidavit, my lord, I have shown in. The original sale deed has been seized. The same investigating officer here lodging the affair. They are not relying on the sale deed. They are relying on a Zamamandi, which is by mistake error. Main things, with regard to a portion of a land, it is the sale deed, not Zamamandi copy. Am I clear?
Now the issue is they think you have given some false documents on the basis
No,
which you
not giving false document. That is not the allegation.
which you on which you got the
EWS certificate.
EWS certificate. There, this is the FIR.
Yes.
The FIR itself says that the original documents might have been misplaced.
Misplaced.
Now, you have appeared before the
Yes,
investigating
my
authority.
lord, my statement was recorded, and even in interim order, my lord will kindly see. Learned PP.
Yes, any further custodial?
Absolutely, my lord.
Lordship,
If he was required to be arrested.
thing is that Lordship, search is going on at present also. Regarding that register Lordship, that register we are not.
Certainly,
Yes. Actually, what happened Lordship,
this EWS certificate needs to be applied physically, means in a physical form, not online. And in that regard, that particular register is missing. A statement of this particular circle officer has been recorded. He has admitted that he issued the certificate, but he didn't verify the family income detail and other things. And he could not trace out the particular entry. And there are other statements also. where
All
no
made by
particular
the-
entry was found. And that regard, investigation is still going on. And few.
Kindly tell us, after the interim order passed by this court, when the person has appeared before the,
Yes.
Yes, yes, yes,
Yes.
yes, yes, yes.
if anything is there on record to show that this particular man is
Like-
required to be
like-
taken into custody for further investigation,
Absolutely.
just tell us that.
Absolutely, madam.
Thing is that, Lordship, we are seeking for the original EWS certificate. And as
For
per
that his-
statement of the petitioner, he has misplaced. And we have wrote a letter to the particular department also, and they have stated that only Xerox copy was submitted. And that original certificate is yet to be found.
But the circle officer says that, yes, I have issued a certificate.
Absolutely.
So because of that EWS certificate, which he says he has lost, he lost a piece of document, he should be taken into custody, yes or no? That is what
In the Lordship, no procedure was followed
by,
by the circle officer.
he is the circle officer.
No,
By
no,
the
no.
beneficiary Lordship. But Lordship, there are some connivance also. That particular circle officer is, happens to be the friend of this petitioner. But of brother, one of the brother, who is one of, he's also accused in other cases, trial is going on. There's some connivance here. And without prescribed, following the prescribed procedure, how he could get a EWS certificate. And because of his being selected, the said category, some reserve candidate has lost his job.
So for that, once the certificate is found to be
Genuine.
It's not a genuine certificate because
if
nothing is there.
the status is found to be not genuine, he loses his job.
Absolutely.
That job goes, you cannot put the clock back to give it to a deserving candidate now. It has to be kept blank and to be
And
given to
Lordship,
someone.
the last model also stated, he didn't verify, he didn't go to the field verification. The statement is here. He has stated.
It is like this, sir. You move a bail petition, it gets rejected. Can we ask people not to apply for a bail? No. So people will keep trying. Can I get this certificate? Can I get that certificate? Can I get this?
Pressing my point.
Just let us have it that way. People will keep trying to get a certificate. This will help me in getting a job. Someone on the top gives him this certificate. Is his custody now required for the investigation is what we are asking. Or even if he's not taken into custody, your investigation can go on. You can come down to a charge sheet.
It's going on.
Fine. Deeply obliged. He'll
Heard
cooperate.
Mr. A.K. Bhuyan, learned counsel appearing for the accused applicant. Also heard Mr. P.J. Burman, learned
Yes.
SPP Vigilance by the order dated 11/9/2025. The petitioner was granted an interim protection, directing him to appear before the investigating officer, and the learned counsel appearing for the petitioner submitted that he has appeared, full stop. The statement has been recorded, yes, Mr. PP?
Yes.
Statement has been recorded. Anything in this statement which you would like us to?
No. He's just-
The learned SPP has submitted that the statement given by the petitioner has been recorded, full stop. The SPP CM Vigilance Cell on 11/9/2025 as recorded by this court had made a submission that there is no apprehension of the petitioner getting arrested as of now.
Yes.
Full stop. Keeping in view the fact that the statement of the petitioner has already been recorded and the other co-accused, namely the circle officer and the lot mondal, have made their statements to the effect that the certificate issued to the petitioner was actually issued may be on wrong facts, comma, this court deems it fit to make the interim protection granted to the petitioner absolute on the same terms and conditions
Yes.
as given in the aforesaid order. Bail
Deeply
petition-
obliged.
Anticipatory bail petition disposed of.
Deeply obliged.
Copy 6.
It's a anticipatory bail, my lord. I am on interim, my lord. The crux of the case, my lord, is that, my lord, whether poppy seeds come within the ambit of NDPS or not.
Because of that, because the official report is because now, there is a clear. Yes, appear, but fact is that. From the copy, only seats are actually, all other, now it is crash. Though in the serial list, this stated that, mentioned that, copy seat crash. So now, crash condition, order is. Like how it can be determined without official that it's crash of seats or other materials. If it is seats, crash of other materials, then it will be in the ambit of NDPS. Now, as for his statements, মই আফিং খিনি কিনিছিলো ট্ৰাক ড্ৰাইভাৰৰ আফিং that then it will be open. So FSL is not available. Anything in interim, my lord?
My lord, poppy seeds, my lord. What we say in, my lord, afu guti or posto dana, my lord. Then all grocery shop owner will be behind the bars, my lord.
Once it is sold in the crushed form,
Yes. Yes.
then things become different. If it had been simple seeds,
But now, my lord, if your lordship goes to a grocery shop, my lord,
the seeds
it's a-
in the solid form.
I am on interim, my lord.
The learned PP has submitted that the FSL report is yet awaited, full stop. Mr. NJ Dr. Learned Counsel for the petitioner has submitted that that the petitioner has complied with the directions given on 28/11/2025 to appear before the investigating officer and his statement has been recorded. Full stop. On the prayer of the learned PP to produce the FSL report before this court, list this matter again on 18th of February 2026. Interim protection granted to the petitioner earlier shall continue.
I am obliged, my lord.
Lordship, FIR is at page 12, Lordship. Allegation against me, Lordship. Section 4 of Poxco Act and Section 9 of Child Marriage Act, Lordship. Page 12, Lordship.
Page 12.
Yes, Lordship. Lordship, what has happened, Lordship, in this matter, charge sheet has filed. Now, another matter is pending before this honorable court by bail application number 65/26. Lordship, may I take this matter along with?
But then the matter has to go to sometime in February. It has to go to the 2nd of February.
2nd of February. Obliged.
Learned Counsel appearing for the petitioner has submitted that another matter appearing out of the same FIR
Yes, Lordship.
is pending.
Yes.
Being
BA number 65 of 2026.
BA number 65 of 2026. Full stop. Learned PP has submitted that the case diary is yet awaited. List this matter again on the 2nd of February 2026 along with the case diary. Take both the matters together.
TCR maybe.
TCR will come. TCR.
Oh.
Because the charge sheet has been published.
Oh, charge sheet. Oh, sorry. Then did this way. Petitioner has submitted petitioner has submitted that there is another bail petition arising out of the same FIR, being bail petition number so and so. He prays that the matters be listed together. Full stop.
Yes.
Prayer allowed. He also submits that the charge sheet has been submitted. Full stop. Therefore, prays that the scan copy of the TCR may be called for. Accordingly, call for the scan copy of the TCR. In
Case number, let's say 104 oblique. Special Poxco case number 104/2025 pending before the additional listing and session judge Sibsagar.
Sibsagar, huh?
Sorry, Lord,
again on
Dibrugarh, sorry.
Dibrugarh. List again on 2nd of February 20.
Obliged.
50. 50.
Your Lordship, I've already granted interim, but before if. let the
You were on
records come-
interim.
Yes, Your Lordship.
Charge sheet has been submitted.
Yes, Your Lordship.
Put up for trial? No. He has been put up for trial.
No, Lordship.
The learned APP has submitted that the petition, that the charge sheet in this particular case has been already submitted by CS number
234/25.
in dated.
30/30.
Uh,
11/2025.
Full stop. The learned counsel for the petitioner has submitted that he had been granted interim protection by this court
Yes, sir.
during the investigation of the case.
Yes, sir.
Full stop. Accordingly, the said interim protection shall continue till
Committal before the
till
session.
his appearance.
Before the committal court, Your Lordship, since it's a sessions tribal case, Your Lordship. Or interim may be
Goes before the
extended and
magistrate on a summon, he'll be immediately put behind bars. The session.
Your Lordship may then call for the charge sheet and hear it on merits, and interim may be extended during.
The interim protection is extended till the committal of the case
Or Your Lordship.
before the learned, to the learned trial court, to the trial court of competence. So, yes, the petitioner would be at liberty to pray for regular bail before the learned trial court. Till committal we have granted you.
Yes, sir.
52.
May it please your lordship. Lordship, this is a pre-arrest bail application, lordship. We have three petitioner before your lordship. Case was registered under 21B and 29, lordship. Recovery is 123.38 gram of heroin from an abandoned vehicle. That is, lordship will find on FIR on page 11, lordship.
Updated CDR. Is there?
So far allegation, lordship, only say age 14, lordship will find. Here, this is the present petition.
One at a time, huh?
Present petitioners are not the owner driver of the vehicle, lordship.
On paper.
Page
Paper, they are not the owner driver.
Yes, lordship. What happened, lordship, in this case, the FIR stated in page 14, lordship will find that on inquiry, it has been learned that the owner of the vehicle involved in the incident along with the associate only specify the name of this person. Nothing has been recovered from this petitioner, lordship. Their house has been searched. Nothing has been recovered, lordship. Now, whether, lordship, the owner of this vehicle has been arrested, lordship, whether he implicated this present petitioner or not, lordship.
Not only that, there are other things are also there. It is a B intermediate quantity, lordship, 123.82 kg, lordship. So there the facts are there, lordship. It is in a field, and the person in whose house the field is there, lordship, in front of him, his house. Lordship, this person went to that place, and he also, these two person, this Anwar Hussain, in whose, this is the person in whose name the car was registered, lordship. He was also present, witness is there, lordship, and one another person, that is Sanowar Kaji. He is also present. He is named, lordship, named by the witness. And however, when this person has been arrested and he was interrogated, lordship, he has also stated that these three persons are his brother-in-laws, lordship. They are doing this business. It is not only that he on his statement, lordship. One of these persons, Sanwari, has been identified by this person, lordship. And when police came there, lordship, these two persons inside the house of the witness, lordship, they fled away.
Material recovered from the abandoned vehicle, lordship. Now, this person is not arrested from the place because they are not found there, lordship. Now, how they could they establish these are the person, lordship, who are present there? Because the person was arrested, they have not implicated this petitioner. Now there's independent, whether 164 statement of their witnesses has been recorded, lordship.
So therefore, at this stage, Because stage we are not inclined.
Because it is not recovered from the present petitioner, lordship. Nothing has been recovered from the present petitioner. If recovered, lordship, the burden lies on
Witnesses
which
have
lordship-
seen, witnesses, independent witnesses have seen you near that car. You are the brother-in-law of the person to whom the car belongs.
They have found inside the car when the car was wrecked,
They
lordship.
come up from the car, it is also stated there.
Lordship, what happened, lordship? They have-
Abandoned, you say abandoned.
Yeah, abandoned, lordship.
Abandoned in the
After
sense,
they fled, the police came, all of fled away. Lord.
Fled with nobody has seen,
abandoned,
lordship. They
I
have
had a
made an-
different impression. I had the impression that it is lying in the field, all moss and trees going inside it,
No,
totally
no.
abandoned vehicle.
No, no, no.
It is an active car which was
Lordship,
from where they fled away, so it became an abandoned car for the moment. Hey.
Lordship, what happened, lordship? They have said they have a videograph enter search, lordship. Whether they have prior information, lordship. When they intercept in the Naka checking, lordship, probably they have, lordship, videographing that vehicle also, lordship. When it is coming, lordship.
Those are some merit points, whether we can grant you an anticipatory bail at
Because,
this.
lordship, recovery is not
Pre-arrest
from
bail
the-
can, should we be considering a pre-arrest
Lordship,
bail is what?
recovery is not from this petitioner.
Could be.
Their house has been searched, nothing has
The
been recovered.
petitioner has not been recovered. Where can there be a recovery from him?
Because, lordship, these are the, because of their associate, only mayor's statement in the FIR said that these persons were associated with the person who was carrying the vehicle, lordship.
It is not.
Driving the vehicle, lordship.
The statement is not by the co-accused. One independent witness has stated that.
Now this independent witness,
And the
lordship.
vehicle of the lordship.
Heard
they have
Mr. So-and-so and counsel appearing for the petitioner. Also heard the learned PP who has produced the case diary in the matter. The
And Caesar, lordship, can see Caesar,
the learned
nobody
counsel
has
for the
made.
petitioner submits that there is no recovery from the petitioner of any contraband,
Yes, lordship.
and he has not been named by any of the co-accused,
Yes, lordship, the arrested accused, lordship.
any of the arrested co-accused, full stop.
Yes,
Any other submission?
that much, lordship.
The learned PP has submitted that there are material, no, the perusal of the PP has submitted an eligible perusal of the case diary shows that there are statements made regarding the presence of the petitioner near the
Petitioner and the owner of the.
petitioner and the owner of the vehicle by some of the witnesses. Full stop.
One of the petitioner, lordship, these petitioners were not, lordship, interrogated, lordship.
Convert.
Sonwar, he was not arrested, lordship.
Sonwar is the applicant.
So Sonwar was not interrogated. How can his statement will be recorded,
The
lordship?
facts and circumstances of the case and the materials in the CD. This court is not inclined at this stage to entertain the prayer for pre-arrest bail to the petitioner, keeping in view the stage of the investigation. Stop. This anticipatory bail petition is therefore rejected at this stage.
Obliged, lordship.
At this stage. Let some more investigation take place. আরো আছে নাকি? Yes.
What's it? This AB is preferred against the rejection of the earlier AB filed before the sessions for Kamrup Amindra.
What is the allegation against you, sir?
Allegation is that the petitioner is a businessman. He is a recycling industry in Amindra. Recycling of these metals. He manufactures utensils. So he has a godown in the Amindra area. The place is North Guwahati under Changsari PF. The allegation is that may read the FIR. Is on page 19. To so and so subject FIR. I would like to report that at around 3:10 PM of today, 12/11/25, one source information received by the additional SP headquarters that a gang of burglars, robbers who had committed burglaries, housebreaking by night at various Namgars, temples, houses of people had taken away various puja copper items and criminally conspired with the owner, manager, staffs of Rhino Karai factory. I am the owner of the Rhino Karai. godown located at Bhetamuk, Goripur to covertly sell the looted copper and other items. It was also informed that the stolen items were covertly stocked there. Based on that input, a police team raided the premises and found huge quantity of temple, Namgar copper items like Tilinga, bell, Soria, copper plates, ghoti, etc. as per the seizure list entered. The weight of the items runs in several hundreds of kilograms and valuation is rupees 15 lakh.
Two
It may be-
persons have been named in the FIR. Who are they?
No, no persons are named in FIR. They
Huh?
first made the seizure.
What? We are reading page 19.
19.
Down below, name and address of the accused person.
No, they accused person, that is, they are
Ranjit
arrested.
Yadav and Shahjahan Ali.
They were arrested. Earlier, the seizure was first made. They were detained. They took them. Then they registered the FIR. The complainant is the police officer himself. There is no temple authority, no committee, no victim. Complainant is police and seizure was made by the police. May I come to the seizure?
And you are the?
I am the owner of the Karai factory and I have the godown and the
That is
seizure
why
was
I am
made from
asking
my-
you, who is Ranjit Yadav?
Ranjit Yadav is my staff.
Is an employee. And who is Shahjahan Ali?
He is also an employee. They were present at the time of seizure in the godown. Lordship may come to the speaker list.
Any FIR to show that these items were stolen? Nothing.
Nothing.
CD? No.
These two persons, Ranjit and their statements are their lordship. They have stated that their owner, this person, bring some persons are there who bring this type of things lordship to their godown, and there are some other persons who brought these things lordship.
So some
is dealing is their lordship.
no, dealing that sale and procurement has to be there. But they are not saying that he brings any
Moreover, the thefts are also not caught, to be honest, lordship.
Heard Mr. So and so learned counsel. Yes. Trade license to do what? Manufacturing of aluminium. Cancel their trade license.
Otherwise, they have not given.
Not say-
reasonable-
See, the theft is not there on record. Your city does not say that it was pursuing this theft, we recovered these items. We would have rejected the petition right away. Yeah, it is a shop. Someone told them, yes, there might be something inside. They go inside, find copper, pick up the employees. Custodial interrogation may not be necessary.
Otherwise, they have not.
He might be able to show from where he has bought, where he has not.
That is not wrong.
Huh?
Lordship, it is on 70 days. I am not being issued a summon event to appear before the IO. It is only my apprehension that I have come here.
We'll give you the interim, go and appear, show them the documents. This is how I got all the things into my shop and
Yes.
happy. Yes. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned PP. The petitioner claims to be the owner of a Karahi factory.
Karahi factory.
Karahi factory, from where the certain amount of copper.
There were many items. but we took only
Copper
and
items
brass.
were,
Copper, brass.
copper and brass items were recovered. And two of his employees, two of his employees were arrested on the suspicion that these material may be stolen material, full stop. The learned counsel for the petitioner submitted that the petitioner deals in such metal, hardware. And he is ready to cooperate with the investigation. The case diary has been received by the learned APP as sought for by the order dated 16/12/2025, and on a pointed query by this court, the APP has submitted that there is no mention of any FIR regarding any theft of such items from the neighborhood area, which could relate the items recovered to any particular incidents of theft or robbery. Yes.
One thing I want to add, Lordship.
However, they have not given any explanatory. Lordship.
He has pointed out
That how they have come there.
the
Position of this thing.
learned APP has submitted that the employees could not explain the how the copper and brass items were available in the godown despite the trade license being one for an aluminum factory. Full stop. In the facts and circumstances, we deem it a fit case where we are
dealing with
the
manufacturer of
the
aluminum
petitioner-
utensils.
where the petitioner will be required to appear before the investigating authority on or before the 29th of January 2026, along with all his documents as may be necessary to have his statement recorded by the investigating authority. In the event of his arrest, he shall be released on bail on furnishing a bond of rupees 30,000 with one surety of the like amount, subject to the satisfaction of the investigating authority.
An updated case report.
List again on 19th of February 2026, along with the updated case diary containing updated case diary. Yes, sir.
Lordship, this is an application for PAS bail, Lordship. And there are 5 petitioners, Lordship. And petitioner number 1 was allowed interim PAS bail. And the petitioner number 1 was allowed interim on interim. For others, there is no interim, Lordship.
What is the allegation?
Lordship, allegation was that it is in the FIR that page 14 type copy.
Have you appeared before the IO?
One has appeared before the IO. But so far the other is concerned, there is no interim, Lordship. Only the allegation is that the APDCL team theft drive was going on in our village, and some people, they said that some people had obstructed them and obstructed the public servants on official duty, physically assaulted them, and property damage to mobile phone were damaged. That is the allegation, Lordship. And the sections, Lordship, the LA sections, the offences
section, it is okay.
Lordship, all except two, Lordship.
Hanifuddin was granted bail because he was having some eye problem.
Yes, Lordship. Yes, Lordship.
Yes.
The offences, Lordship.
Updated CD, any CD available?
I want to one thing. Though I have not found the statement, but in the note, IO note, it stated that Lordship, the accused stated that he has been financial injured. So he may be appeared, I don't know, Lordship, but because there is that he had stated. So I presume that he has stated nothing. But statement I have not found. Moreover, regarding Lordship, injury, the person victim has suffered Lordship simple injury. Is there. And however, one of the statement of the witness is also there, who has specifically stated this person's name, Hanifuddin. He has stated that he has not done anything and he has not made any physical assault. And Lordship, he has not taken part in the assault and did not provoke the crowd and did not interfere with the activity. All of that statement of the witness is there, Lordship. And regarding other witness accused, Lordship, the statements of witnesses are there.
They have participated in that.
They stated they were present and they have assaulted.
The smart meter thing, people are aggrieved with that.
Lordship, 121, so far as 121.2 is concerned, that is for grievous hurt, Lordship. If it is not grievous hurt, then it will be bailable.
Bailable.
Yes, Lord.
Updated CD, heard Mr. So-and-so learned counsel appearing for the petitioner also. Petitioners also heard Mr. So-and-so learned PP who has submitted that as per the case diary. The injuries, the alleged injuries received by the victims during the scuffle are simple injuries. Full stop. And simple injuries, full stop. Although the scuffle has been referred to by some of the witnesses, regarding the other petitioners, full stop, there is no allegation by the any of the witnesses till now against the petitioner. Petitioner number one, and in fact, one of the witnesses have stated that the petitioner number one was not involved in the entire episode. In such view of the matter, the interim protection granted to the petitioner number one is made absolute. Made absolute. As regards the other petitioners, comma, they are directed to appear before the investigating authority within a period of within 30th of January 2026 to have their statements recorded and participate in the ongoing investigation. Full stop. It is provided that in the event of their arrest, para 5 of order dated 18/12/2025. No, we are closing it. Anticipatory bail petition is accordingly disposed of.
Objection.
Earlier one, we are making absolute. For
Yes, yes.
petition number one, the rest on the same conditions.
On 30th, within 30th, I
You
have to
appear.
Yes.
On the failure of the petitions to any of the petitions to appear, petition number 2 to 5 to appear before the learned, before the investigating officer, comma, the privilege of pre-arrest bail shall lapse. Yes. 56. Case diary. Not available.
Objection, Lordship.
Oh.
You will look up FIR, Lordship.
What is the allegation against you, madam?
The page number 9 is the FIR, Lordship. May I read, Lordship?
You are who?
I am the accused number 1 in the FIR, petition number 1, and the accused number 2 is a petitioner number 2.
You are 1 and 2.
Yes, Lordship.
At this stage, without the CD, can we?
Lordship, already one bail is rejected by the land below code, Lordship, and I want to cooperate with the IO, Lordship, because it's a completely false cases, Lordship.
We understand that, but
because, Lordship, I was filed this matter December 17, Lordship.
Ah.
Then after 1 month, 2 days, then they not send the CD, Lordship.
yes,
That's
why
why
is the CD not coming up? No, 19/1 was the last working day. You got it immediately on the reopening, almost immediately on the reopening, nothing big.
in the meantime, if charge sheet is submitted, then they show absconder because I already tried to.
We'll set it aside, come back. We'll set it aside. If you're appearing before this court, how can you be an absconder? You're pursuing your legal remedies. We'll have it on the second, madam. On the second.
Sure. Much obliged.
Third, Ms. So-and-so and counsel appearing for the petitioner. The additional PP has submitted that the case diary is awaited. Huh? The case diary is awaited. The case diary had been called for by the order dated 19/12/2025, full stop.
Lordship,
The learned APP yes.
possible then 30 January. Because I'm not protected, that's why, Lordship. I'm not protected, that's why. AB, but maybe.
It's an AB. List again on the 30th of January 2026. By which time the learned APP shall ensure receipt of the CD.
57. Much obliged.
Yes,
Thank
sir.
you, Lordship. Lordship, similarly situated co-accused have also preferred a anticipatory bail application that is fixed tomorrow, Manoj. And there's an instruction also that the names of the people that it has been charge sheeted, this matter, Manoj. The names and the involvement has to be apprised before this court. So, my lord.
In the other case.
In the other case. That is fixed before my lord only tomorrow, item number 39.
List along with AB number?
AB number 2890.
2890 of 2025.
202.
Stated to be listed on 22.
My lord, with regard to the part that the name of the present petitioner, we also inquired his involvement in the charge sheet because in that order, of the other co-accused, it has been asked to inquire about their involvement in the charge sheet.
Give us the name of all the petitioners tomorrow. We'll search it out one by one.
I would like.
Huh?
It will.
Tomorrow, কালি বোলে একেখন FIR হেৰি আছে। Yes.
59. Maybe yours.
CD? Oh.
Simple allegation, my lord. Get it loaded, my lord. Coming from Mongol.
Simple allegation.
My lord. All are bailable section, my lord, except 379. My lord, 317, my lord. Police suspected the stolen cattle, my lord. But I have annexed all the received, my lord. And learned trial court, co-accused person already unlocked on bail, my lord.
Who are you?
I am a petitioner. One is my lord, cattle purchaser, and another register owner, my lord, vehicle owner, my lord.
How do you load this 38 cattle? 6 of them dying in the vehicle itself.
Yes, my lord, that is called by the, that's done by labor and my lord, driver and handyman, my lord.
Huh?
Driver and handyman, that.
They did it.
They are
you are the owner and you do not know who is loading your cattle, how many number in which truck.
I have purchased. I have purchased and directed them to
transport it, giving them one truck for 44 cows.
My lord.
Is there not some stricter punishment for causing this kind of?
Moreover, postmortem recording also based was duty caused by omission.
Cruelty is there, but cruelty is bailable, my lord.
Huh?
Cruelty is bailable, my lord.
Which is not bailable?
Cruelty.
No, what is not bailable here?
317, my lord.
What is 317?
Lordship will file page 42, my lord. In bail order of the co-accused, my lord.
Co-accused?
Driver, handyman, my lord. Page 42, my lord.
Don't show us that because that is there. The question was whether further custodial.
My lord, diaries appear there. The major part of the investigation has already been done by the IO. That a part of the accused person are in judicial custody since long, so there is also no prayer from side of the IO for further detention of the accused person.
We can allow him to go and appear, the owner, to produce the documents before the IO. Show us that the documents does not relate with those cattle.
But one thing I want.
We'll reconsider.
One thing, Lordship, I want. The statement of the persons who were in the driver and other persons, their statement stated that one aspect was the owner, Lordship, of that cattle. But in the petition, it has come up another person. I don't know about that one.
The learned APP has heard Mr. Swenson, learned counsel appearing for the petitioner. The learned PP has submitted that as per the version of the arrested co-accused, the owner of the petition, owner of the cattle seized are different from the petitioner number 1. Full stop. The learned counsel for the petitioner submitted that the petitioner number 1 has got the requisite documents to relate the cattle to purchased by him. Full stop. In the facts and circumstances aforesaid, we allow the petitioner number 1 to appear before the IO owner before 30th of January 2026, along with all relevant documents to show that he has purchased, to assert that he has purchased the cattle which were seized from the vehicle. Full stop. In the event of his arrest, he shall be released on bail on furnishing a bond of ₹30,000 with one surety of the like amount, subject to the satisfaction of the investigating authority. Call for the updated CD updated CD. Full stop. The IO shall also inform the court whether the purchase slips relate to the particular cattle which have been seized. Full stop. The learned PP shall also have instructions as to whether the owner of the cattle stated by the co-accused have been recorded or not.
As per petition number 2, my lord, is
List again on
register owner, vehicle owner, my lord.
13th of February, huh?
Vehicle owner, my lord, respondent number.
Let him run around for some time. If he can put 44 cows in one vehicle,
My lord.
let him stay somewhere else for some time. Huh? 13-2.
Obliged.
Yes.
Wait, please, your lordship. Lordship, this is an anticipatory bail application, lordship. Last occasion, lordship has directed with 70, lordship.
Charge sheet, it has been charge sheeted.
Charge sheeted, lordship.
And
May I please this lordship order of the High Court, lordship, when Supreme Court, lordship, regarding lordship after filing of the charge sheet, lordship.
What can we do after the charge sheet?
Paragraph number 9 and 10, lordship. Here is the case, lordship, of a similar nature, lordship. The charge sheet has submitted, lordship. In the meantime, someone was issued, lordship. The finding of the Supreme Court in this regard, lordship, paragraph 9 and 10, lordship.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP, who has submitted that the charge sheet has been submitted after due investigation. Learned counsel for the petitioner has drawn our attention to the case, to a judgment of the Apex Court rendered in SLP criminal number 18081 of 2024.
Yes.
Decided on 17/1/2025, where the Apex Court has observed that once the investigation is over and charge sheet is filed, then the accused should be asked to appear before the court concerned and should furnish bail to the satisfaction of the trial court. In the said case, the Apex Court had directed the petitioner to appear before the concerned trial court and furnish bail to the satisfaction of the court. Full stop. He has prayed for a similar relief from this court.
However, lordship, paragraph 10 said, lordship, if at all the investigation officer want to interrogate the petitioner, he could.
We are coming to that. He has prayed for a similar relief, submitting that that once the investigation, that if at all the investigating officer wanted to interrogate the petitioner, he could have been arrested during the course of the investigation itself. And there was no point in making a formal arrest after the charge sheet has been submitted. Full stop. In the facts and circumstances, the prayer of the counsel for the petitioner to allow the petitioner to appear before the concerned trial court to pray for regular bail is granted, and it is observed that now there is no point in the investigating officer attempting to make any formal arrest of the petitioner after filing of the charge sheet. That will do.
Obliged.
Mr. Dotto. Which item?
64, I am for respondent.
Okay. Etu kuntu matile? 66 or 60? Yes, madam.
May I please, your lordship, this matter is infractuous, lordship.
The matter has become infractuous.
Lordship.
Miss A. Begum, learned counsel appearing for the petitioner, submits that the matter has become infractuous. Full stop and accordingly prays that the matter may be closed without further adjudication. Full stop. Criminal revision petition is accordingly disposed of is closed. Don't say disposed of, is closed. Huh? Closed. Service report?
Service report, my lord, we took a step, my lord. AD card not received, my lord.
So, go before the Loazima court, give their proof of service. Huh? On the
Matter may be listed before Lozima court.
List this matter before the heard Mr. A. Ali Learned counsel for the petitioner.
Maybe a question.
The office note dated 7/1/20 26 reflects that neither AD card nor unserved notice nor any service report in respect of respondent number 1 has been received by this section till date.
Oh, my lord,
So you are repairing. Mm. For? Huh? He met with an accident? What kind of an accident? He was driving a bike or something, or in the car? Minor. Although the office note dated so and so delay, however, Miss S. Barua appears on behalf of Mr. A.K. Bora. Huh? L.K. Bora. For the respondent number who submits that they are under instructions to appear for the respondent number 1. Full stop. Accordingly,
Sole respondent, only one respondent.
Sole respondent. Accordingly, service of notice on the sole respondent is complete. Full stop. List this matter again when. But we cannot consider the interim.
There is no interim order. We actually prayed for interim. That was not allowed.
What was the interim prayer?
Interim prayer is there, my lord. Page number 7.
No, we have to accommodate them for today.
My lord, that may be one. That is why, my lord, some
we'll take it, we'll take it up on early on February.
Yes, first week maybe.
First week we cannot do it. We'll have it on 13th of February. 13th of February. List this matter again on 13th of February. For consideration of the
interim prayer.
Interim prayer. A prayer for interim relief by the petitioner. Full stop.
May I please as well, office note dated 19/1, your lordship, service upon respondent number 2 is not complete, your lordship.
TCR to ahile niki?
LC has been received, your lordship.
I say. Should you go? Are you under interim protection?
No, your lordship.
What was your what is proceeding? Something was to happen on 17/12/2025. What had happened before the Learned Trial Court? With service of notice on the respondent number 2. Can you tell us what has happened on the
No, your lordship, on 17, your lordship, not available.
list again on
Short date may be given, your lordship.
11th of February 2026.
Oblige, your lordship.
64.
This is for modification of an order granting bail. One condition, your lordship. Your lordship will get it at page 10.
Page 10?
Page 10. Condition is number E, your lordship. Page 12.
Number E.
E. They would not leave the territorial limits of trial court without the written permission of the trial court. Now, your lordship, I am cooperating with the trial, your lordship. Already around 30 probably witnesses has been examined, your lordship. Now I have to move around, your lordship, since I am no more in the job, your lordship, for business purpose, your lordship. That's why, and similar order has already been passed by this honorable court, your lordship, in respect of other co-actors, your lordship. Your lordship will kindly come to page 18, your lordship. Same condition has been your lordship waived. Page 18.
Page 18.
This was way back in 2023. Page 20, para 6 is the order.
So now they do not need to take the permission of the
Lord,
trial court
Lord.
to.
Otherwise, I am cooperating, your lordship.
Yes.
But actually, he is cooperating with it, but earlier his civil application was rejected by the.
That I have annexed, your
So
lordship.
he has annexed.
Why was it rejected? By whom?
Not sure.
That's your lordship in 2020. Now
Can we have that annexure 2? Huh. Okay. Heard Mr. So learned counsel paying for the petitioner also heard Mr. So learned special public prosecutor. This application has been filed praying for modification of condition number E in bail order dated 11/10/2018 passed by the passed by this court in BA number 2170 of 2018 full stop. The said condition is reproduced for a easy reference, reproduced from page 12, clause E. The General Counsel for the petitioner submitted that the petitioner has been cooperating with the trial and is also ready to further attend all proceedings in the trial. Full stop. However, since the petitioner has to, however, a modification of the aforesaid condition would enable the petitioner to also arrange for his livelihood during the time of the proceeding, during the time of the trial. Full stop. The learned special PP has drawn the attention of this court to the order dated 25/2/2022, whereby an earlier similar prayer had been rejected by this court. The learned counsel for the petitioner has submitted that it was at the initial stage, and now with the change in and now with the passage of time, it has become necessary that the aforesaid condition may be modified. Full stop. Having due consideration to the submissions made, this court is of the opinion that the aforesaid order can be modified. The aforesaid order dated 11/10/2018 passed in BA number 2170 of 2018 can be modified to the extent of deleting the aforesaid condition, as has been done by this court in other similar cases arising relating to the same trial. Full stop. Accordingly, clause E of the order dated so and so in BA number so and so shall stand deleted. Henceforth, full stop. I criminal disposed of. Deeply. You only come in special cases or?
Only for this, the special case number 5/21 and 2/27.
All
requiring special attention.
All special cases.
All special cases?
Only special advocates.
Only.
Deeply obliged.
Thank you. Yes, 72.
It relates to my lord custody of the vehicle. Earlier the board below trial was rejected my petition for custody of my vehicle, which was seized in connection with the my lord NDPS case moment. So
when was it seized?
It was seized on 28/12/24, almost more than 1 year. It's been languishing in the police station, my lord.
What kind of a vehicle is it?
It's a Bolero, man.
Bolero.
Bolero vehicle.
Huh? Who is respondent number? Respondent number 2.
They can appear. Because
So you can
they
appear
can
for
appear,
him.
because
I see you can appear now from 2024, that vehicle is lying unattended.
And trial has
Eh?
not started, my lord. I feel that.
Eh?
Trial also not started yet. Although
Yes.
charge sheet is not there.
Bolero pickup, Bolero vehicle, NDPS maybe.
Sir, no, that is no conflict. That
He would be taking custody of the vehicle, helping him run it. The day you want to confiscate it and you want to destroy that vehicle, he has to hand it over to you. In a as is where is condition, of course, after removing the AC and everything. And
the decision of Sundar by Ambalal.
where was the heroin found? Let us see.
My lord?
Where was the this thing found? Where was it hidden? Where was it hidden?
That is 11 is just affair, my lord. It is parked in a hotel, my lord, a parking lot, from where the vehicle was searched and then it was found.
Yes, sir. Can you tell us from where it was seized? Inside the vehicle.
From that part is.
Huh? You want the vehicle, you have to tell us, sir.
Yet simply it is only.
You want to keep the vehicle, you have to tell us. And if he wants the vehicle, he has to tell us. Somebody tell us.
Go to the affair, man. That is no, it is not specific, man. Clear that, except that it is found in the vehicle, man. The commercial quantity that is there, man. That is there.
Kept at the backside in a blue bag.
In order.
Let us understand it this way, Mr. Parashar.
FIR.
We'll give you time to have your instructions. Have it by the 2nd of February. This is a vehicle, this is a case where the the contraband has been found in a blue bag inside the vehicle.
Yes.
The vehicle itself was not being used to hide it.
Yes.
It was being only simply used by the persons who were carrying it.
Yes,
Why do you
yes,
need to
madam.
keep the vehicle with you? Tell us that.
Hmm?
On the 2nd of February. Huh? TCR is there. TCR is there on the 2nd of February. Let him say why he wants to.
That is already there in the matter, whatever it is there, and the FIR also it is clear, not clear, except it is found in the vehicle, man. That part.
That you could not tell us. That we had to
and the
search
charge
for
sheet
you.
also, we have got it, my lord.
That we had to search for you, sir.
Charge sheet also is there, my lord, but annexed it, my lord.
In order.
In a blue bag. Is it? The vehicle itself was not modified to hide anything.
Not really.
Nothing.
It was seized, my lord, at the time, in his presence, man, all these things.
Huh?
It was parked in a hotel, my lord, and those contraband's were.
You are the owner.
I am the owner, man.
Kindly explain how that bag came to your vehicle.
Because there are other passengers who are also there. Maybe they are carrying, these are passengers of commercial vehicle.
Commercial vehicle.
Commercial vehicle. man.
Commercial vehicle.
It was.
I don't think it is a commercial vehicle, sir. Where is the document? Where is the RC?
RC,
Copy of the RC?
Commercial mining. What is it? Registration at 31. I think man is page 31. Man. I'm just.
It is transported from contraband to transport Dilmapur to DC. Page 35, transported. Therefore, next 27, 12,
35.
On the 2nd of February 2026, allowing the learned APP to have his instructions from the respondent number 2, whom he states he can now represent. On the last occasion, he was required to tell us whether he can.
Seizure list is also have annexed, but they can kindly produce, but that we also will make it clear, lordship, regarding the seizure, where it is found. Seizure list page 32, my lord.
Sir, respondent number 2 remains unserved. today the APP has made a submission that he can represent. I must give him some time to have his instructions, if any. Can I release the vehicle without?
Point then.
Huh?
Only on that point.
We pointed it out to you that this vehicle is not modified.
Yes, that.
You did not take that pain.
My lord.
You did not take the pain. I had to take the pain to find out whether the vehicle was being modified or was there any secret
No,
chamber
there-
or not.
there
No,
is no-
please,
nothing-
please next.
Requirement regarding modification and.
There is no modification. Yes. Huh?
Service awaited on behalf of the opposite party number 2, Lordship.
Await service report on the respondent number 2. List again on 17th of February. Interim orders passed earlier shall continue.
Obliged.
May it please, Lordship. In this case, Lordship, the petitioner challenged the proceeding of the CR case, Lordship, pending disposal before the landed GMFC Kamrup.
Looking at the time, we would like a very short submission on what can be done today. It has already been admitted.
Lordship.
And
Stay has been granted.
Stay is there. We'll fix it sometime in February 17th.
Lordship.
17th of February.
Lordship.
এইটো কি কলমত আহিছে অৰ্ডাৰ চুট হিয়াৰিঙত আহিছে the matter present Mr. So-and-so this matter could not be taken up for hearing today due to paucity of time at the request of the learned counsel for the parties. List this matter again on the 17th of February for hearing. Interim orders passed earlier shall continue.
Deep table.
Yes.
Your Lordship may have some day, my lord, for hearing this matter, my lord.
I am having?
Your Lordship may have it some other day because hearing matter, my lord, this will take some time.
What is the issue about?
Issue, in fact, this is the application, my lord, filed by the woman, my lord, and that has been, my lord, dismissed by the London trial court, my lord. Then there was an appeal, my lord, that was allowed, my lord. And here, my lord, against that appellate order, we have come before this court, my lord. In fact, there was an interim order that has been vacated, my lord. So there is urgency in that effect.
There was an interim order in your favor.
And that has been, my lord, vacated by this court.
Why? When was the interim order passed?
Interim order was, my lord, at the very, my lord, at the very, my lord, initial stage, my lord.
Ironically, we do not find that interim order here. Why?
That is, your lordship will kindly. That is,
yes.
Yes, sir. That is
16/7.
16/7/2025.
And thereafter, they moved an IA.
My lord, respondent, my lord, moved an IA, my lord. For
Although the
vacating my
counsel for
interim
the-
order.
Although the counsel for the petitioner is present, none appears for the respondent on call.
Yes, ma'am.
Due to paucity of time, the matter could not be heard today. List this matter again on the 17th of February 2026.
Can I have some earlier date, my lord? Because there is no stay order as on date, my lord.
What were you required to do? What?
Your lordship may have it, my lord. It does first week or second week of February, my lord.
What difficulty are you facing is what I'm
In fact, my lord, because of the stay order is vacated, my lord, now I am, my lord, liable to pay the entire, my lord, maintenance amount, my lord.
What is the maintenance granted?
Maintenance is, my lord, towards the woman that is, and one child, my lord, they are claiming, my lord.
Total of 4,000. You don't
Yes,
want to
sir.
pay your child.
No, in fact, my lord,
Child is yours.
child is, my lord.
Woman is all bad, but child is yours.
In fact, my lord, I will, my lord, submit that he is also, my lord, maybe an illegitimate, but he is not my child. My lord.
Nothing doing. Supreme Court has said that if it is born within your married time, you have to. Day before yesterday or a few days ago, a week ago. If the child is born
Yes.
during the period of marriage,
In fact, there was no
your
marriage.
responsibility.
In fact, there was no marriage, my lord. And that is, my lord, admitted in the, my lord, appellate court judgment that the boy who was, my lord, below age, my lord, at the time of marriage, my lord.
But the stay was vacated when?
That was sometime back, my lord.
We'll take it up on 17th.
Lordship. Deeply obliged.
We will. শেষ করবো পারিস? It has become a habit now. Watching the clock and finishing it at the last hour. Thank you.